ಬರಲ್ಲ ಅಲ್ಲ ಬರಲ್ಲ
Court officer. Sir. Court officer, sir. Sir, serial number 17. ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್, ನಾವು ಇಲ್ಲಿ ಹ್ಯಾಂಡ್ ಇದು ಮಾಡ್ತೀವಿ. ಸುಧಾಡಿ ಅಂತ ಸರ್.
ತಗೊಂತೀನಿ ಮೇಡಮ್, ಒಳಗಡೆ ತಗೊಂತೀನಿ. 17 ನೀವು ಸೀರಿಯಲ್ ನಂಬರ್ ಲಾಗಿನ್ ಆಗಿ.
17 ಸರ್.
ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡಿದ್ರೆ ನಾನು ಬೇರೆ ಪ್ರೆಸ್ ಮಾಡಿಬಿಟ್ರೆ ಹೊಟ್ಟೋಗ್ಬಿಡ್ತೀರಿ. ಸೀರಿಯಲ್ ನಂಬರ್ ಲಾಗಿನ್ ಆಗಿ.
ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಏನಪ್ಪ?
End of the list one matter for
ಏನು?
Gram Panchayat no confidence motion. Please.
Adjournments, page 11, 49 to 51.
Lord, serial number 49, my lord. I am representing Udayad Gaddi. He had been to hospital, man. For general checkup or what, I don't know, my lord. He has intimated me.
49
Day after tomorrow.
submitted, the counsel for the petitioner is unwell.
Day after tomorrow.
Take a chance on 24th. Doubtful.
Day after tomorrow. Please,
Day after tomorrow on the chance hill. 24th.
we'll take a chance.
24th.
My lord, serial number 51, my lord. I'm the proxy counsel for the petitioner's advocate. There's some personal inconvenience. Your lordship may have it next week, my lord. We have informed the government. 51.
Amendment Madilla.
Lord, I'll inform, my lord.
51 at the request of counsel for the petitioner relist on 10th, 13th March. If by then the amendment is not carried out, and amendment petition not filed, the petition will be liable to dismiss for
Please, my
non-prosecution.
lord, please.
Page 12, 52 to 54. Page 13, 55 to 59. Page 14, 60 to 64.
But serial number 62, my lords.
Hmm.
That's my request for 1 week time, my lords.
At the request of counsel for the petitioner relist on 13th March,
That's interim order.
interim order earlier granted is extended till next date.
Page 15, 65 to 68.
Represent Kannur, 66, my lord. Next week I inform Angadi.
At the request of counsel for the petitioner relist on 13th March,
Page 16, 68. Page 17, 69 and 70. Page 18, 71 to 74.
Your Lordship, seal number 72.
hmm,
I request my lord next week, Lordship.
72 at the request of petitioner 13th March,
Interim order.
interim order.
Page 19, 75 to 79. Page 20, 80 to 85. Page 21, 86 to 92. Page 22, 93 to 97. Page 23, 98 to 104.
Serial number 102, my lords. 102.
Hmm.
For KIDB, my lords. Recently have been directed by your lordship to take,
102 learned counsel for respond number 3 and 4 seeks point is granted 2 weeks time
please.
to file a statement of objection. Objection if any by 7th March, relist on 13th March.
Please.
Interim order idea?
Page 24, 105 to 107. Page 25, 108 and 109.
Not 108, not 2 weeks time.
Yes.
108. 108 on 2 weeks time.
At the request of counsel for the petitioner, relist on 13th March.
Not mine.
Huh?
Respondent.
Yes.
Day after tomorrow.
Day after tomorrow, I'll reach agala.
Oh, this is 2017 matter. It has been renumbered in the year 2024. This is with regarding to Uttarazi matter.
7.
24 renumber.
Then wait, please. 17.
Page 26, 110. 110.
Lordship, one request. Seal number 21, your Lordship. I feel for the
Wait till then, please. 21, wait, man.
1. Aruna Deshpande.
Lord, I appear for the Lord respondent in this matter. Lord.
Yes. Yes, Ms. Naik.
Lord, this is the matter where
Petitioner yarilva.
Aruna Deshpande.
ಬೆಂಗಳೂರಿಗೆ ಹೋಗಿದ್ದಾರಾ ಯಾರು ಏನು? None appears for the petitioner. Relist on 13th March.
2. Vittal Teli.
Number 2. In connected matter, there is objection, my lords. Respondent number 2 to 8. No details are provided. They are the LRs of the original landlord. I had made a submission. In connected matter, they are the respondents, my lords.
Two, learned AGA accepts notice for respond number 1 to 3.
Lord, 1 and 2 ಅಷ್ಟೇ. First matter.
ಎಲ್ಲಪ್ಪ, ಇದು
Deputy
ಬೇರೆ
Commissioner and Assistant Commissioner ಅಂತ ಅಷ್ಟೇ ಮಾಡಿ.
Tahsildar. Sorry, my lords. My bad. No, lords, Tahsildar.
They have been
Anjana.
subsequently added.
Anana, Danaji.
Tahsildar Belagavi. Kere.
ಇನ್ನೊಬ್ರು ಎಕ್ಸ್ಟ್ರಾ ಇದ್ದಾರೆ, ಆಮೇಲೆ ಒಬ್ಬರು ಸುರೇಶ್ ಸತೀಶ್ ಬೇರೆ ಹೆಸರಿದೆ. ವೇರ್ ಇಸ್ ಮಿಸ್ಟರ್ ಮಗ್ದೂಮ್?
ಇಲ್ಲ, ನಾವು
ಶರತ್
here.
ಮಗ್ದೂಮ್.
He has become good. Lords,
Same family. Shri Sharad Magdum, who has filed.
Lords, I had filed wakalat NOC, but it has been not disclosed. On 12/2 itself, I had
ಅಲ್ಲಪ್ಪ 101357 ನೀವು ಫೈಲ್
filed
ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ. I had filed wakalat.
ಅದರಲ್ಲೂ ನೀವಿದ್ದೀರಾ?
Adರಲ್ಲಿ filed ಮಾಡಿದ್ದೀನಿ.
Against the same respondents.
Same respondents, petitioner, same petitioner.
So you are going to appear for the petitioner also and respondent also.
No, lords, in connected matter, I have not appeared for
Lord,
respondent.
in
Both
one-
are petitioners. Both
First matter ಅಲ್ಲಿ ಪುಂಡಲಿಕ್ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ?
connected matter ದಲ್ಲಿ ಪುಂಡ್ಲಿಕಿಗೆ appear ಆಗ್ತದೆ. ಶರದ್ matter ದಲ್ಲಿ ಶರದ್ has issued a no objection for me.
ಇದರಲ್ಲಿ ಪಾಂಡುರಂಗ್ ಇಲ್ವಾ? ಪುಂಡಲಿಕ್ ಇದಾರಲ್ಲಪ್ಪ.
ಪುಂಡ್ಲಿಕ್ ಇದಾರೆ, ಎರಡರ ಕೇಸ್ನಲ್ಲೂ ಪುಂಡ್ಲಿಕ್ ಇದೆ.
ಪುಂಡ್ಲಿಕ್ ಇದ್ದಾರೆ.
Panduranga and Pundlik is the second case. First case is only insofar as Pundlik is concerned.
ಕೃಷ್ಣ ಬಾಯ್, ಜಯರಾಮ್ ವರ್ಕೆ, ಶಾಂತಿಬಾಯ್, ಶಿವಾಜಿ ಬುಡ್ಕೆ ಅವರಿಲ್ಲ. ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
ಹೌದು. One submission.
Yes.
In 2.1, my lord, they have challenged the land tribunal order 1996. There is a delay of 18 years in filing the land tribunal. That is in the year 2022 after filing of the first petition.
First you convince us on the delay.
Till 2014, my name was appearing in the record of rights. I had not produced those records. I will place it, my lords, on Monday or Tuesday. Only to show that, my lords, till 2014, my name was continuing. Only on that ground I am before, my lords. In the year 2014, my lords, the connect respondents.
The request of counsel for the petitioner released on 24th.
Please.
3 ಅಭಿಷೇಕ್ ಕಲ್ಲೇತ್.
Date ಯಾವಾಗಂದ್ರೆ?
Yes.
Lords, in this last occasion,
Yes, Mr. Kale.
stage of the case. Investigation is taken up. And it's pending consideration. Comments have been called for. Respond number 6 and 7 in that my lord, complaint. They have submitted their comments.
Adjourn to 4/4.
Yes,
So we'll adjourn this also after 4/4. See what happens.
please.
Notes. Along with the inquiry that is pending before Lokayukta, the order is towards victimizing the petitioner, not only on the lines
So
of
we don't know. Let's get the comments and see whether that is right or wrong.
why,
ಇನ್ನ
because
ಇವಾಗ ಅವರು ಕಾಮೆಂಟ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ದಾರೆ, ಬಂದಿದೆ. Whether your complaint is proper or not is not.
I concede to
You have been falsely filing is their allegation.
notes, but there
Until we get that report, we won't be able to decide that.
there is a NACO guidelines recommending me to continue for a period of 1 year. There was insistence by the respondents.
NALCO is not in charge of the day-to-day affairs. If you are indulging yourself in these kind of things, then why should they continue you?
Lots, the State AIDS Control Society, it is implementing the program under the National AIDS Control
Are
Organization.
they in charge of the day-to-day affairs?
But the
Are
extent,
they in charge of the day-to-day affairs?
moments,
Then,
but the extension of
do
it,
they know what you are doing?
certainly not. But
Do
as,
they know what you are doing?
moments,
Then how are you relying on them?
as regards the extension of contract members,
Sri Anil Kale, learned counsel for the Lokayukta, has filed a memo dated 17/2/2025. He submits that the comments have been called for from response number 6 and 7 and the matter adjourned to 4/4/2025 when orders would be passed.
Yes, my lord.
When orders would be passed.
On
Relist on
4/4, my lord,
8th April.
please.
for, to enable Mr. Anil Kale to place the order passed by the, passed in the above matter, by the office of the Lokayukta before this court.
4, Anil Kale.
In this case, my lords, on last occasion, this honorable court had directed me to, my lords, ascertain under which circumstance, my lords, seal deed at annexure F was passed. In that case, my lords, allottee had already paid the amount well within time in the year 1969 itself.
Everything was paid.
Everything was paid. I have produced allotment letter and, my lords, receipt for having paid the entire amount in the year 1969 itself. That was laches on our part.
Yes, Mr. Kale.
Nami documents.
ಏನಿಲ್ಲಪ್ಪ ಇನ್ನೇನು ಇದ್ರ ಮೇಲೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನಕ್ಕೆ ಪೇಮೆಂಟ್ ವಾಸ್ ಮೇಡ್ ಆನ್ 18/2/1969 ಟೋಟಲ್
240 ಅಂತ ಇದೆ
ಎಲ್ಲಿ 240
ಡೆಪಾಸಿಟ್
ಹೌದು 240
ಬ್ಯಾಲೆನ್ಸ್ ಟು ಬಿ ಪೇಡ್ ವಿತ್ ಇನ್ 60 days 1620 ಅಂತ ಇದೆ ಆಮೇಲೆ
1620 was paid on 7/5/69. Entire amount was paid. ನಿಮ್ಮಲ್ಲಿ ನೀವು ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ, ಸೊ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಬರಲ್ಲ.
ಒಂದ್ ಡೇಟ್ ಕೊಟ್ರೆ ನೋಡಿ ಹೇಳಿ.
ಅಲ್ಲ ತಾವೇನ್ ಮಾಡ್ತೀರ ಮಾಡಿ
ಏನಾದ್ರು ಇದ್ರೆ ಕೊಡ್ಬೋದಾಗಿತ್ತು. Your allegation was you are discriminated and you relied on this. We asked them to produce it. There's no discrimination. Only we can direct them to consider you in seniority in the next time.
If it is.
Petitioner is before this court seeking for the following leaves. The petitioner had applied for allotment of a site in Mal Maruti Extension, Belgaum, in presence of which a decision was taken by the corporation in the council's resolution number 352 dated 30/4/1994, and a site in CTS number 9282 plot number 36 in sector number 5 measuring 40/60 with a total value of 27,750 was allotted to the petitioner. Wide allotment letter dated 28/1994. The petitioner, though, deposited a sum of rupees 3,000 deposited sum of rupees 3,000 initially and a further sum of rupees 14,610 on 21/10/1994, totally amounting to 17,610. However, thereafter the petitioner could not make payment of the balance amounts. The petitioner approached the respondent authorities on 12/2/2024, seeking permission to deposit the balance amount. Petitioner undertaking to pay any fine that may be called upon to be paid by the petitioner. This request came to be rejected by the respondents on 16/2/2024. His challenge in the petitioner is before this court. The submission of Shri Anil Kale, learned counsel for the petitioner, is that in similar other matters, the respondents have accepted the payments made subsequently and executed a sale deed. The petitioner has been unnecessarily targeted. The respondents could well accept the balance amount along with any fine that they could levy and execute a sale deed. In this regard, reference was made by him to the allotment of site bearing number 426 in the very same Mal Maruti extension. It is in that background that Shri Chetan Munoli, learned counsel, appearing for respondent number 1, was called upon to obtain instruction and make a submission as regards the allegations made. Today, a memo dated 17/2/2025 has been filed enclosing the details of the allotment and the receipts for payments made by the allottee in this said matter. On that basis, it is contended that the allotment having been made on 18/2/1969 for a total sum of rupees 2,400. Initially, the allottee had made payment of sum of rupees 240, followed by a sum of rupees 480, and the balance sum of rupees 1,620 was paid on 7/5/1969. Thus, the entire amount having been paid, the petitioners had executed a lease cum sale agreement in the year
2022,
2022
2/6/2022.
on 2/6/2022. And as such, there is no fault on part of the alertee in the said matter. The delay being on account of the corporation had executed a lease cum sale belatedly. Having perused the documents, it is seen that in the matter where Mr. Anil Kale had contended that there was a discrimination inasmuch as a sale deed was executed in respect of another allottee belatedly, the submissions now made would indicate otherwise, inasmuch as that allottee had made payment of the monies way back in the year 1969, and only a sale deed which came to be executed in the year 2022. In the present matter, the petitioner has paid an amount of rupees 17,610 out of total sale consideration of 27,550. The last payment having been made on 21/10/1994. Thereafter, no payments have been made for last more than 30 years. In that view of the matter, I do not find any equities in the claim made by the
Next, sir,
petitioner.
C, D, and E. Judgments of this court, wherein, my lord, the payments was not paid. Next year, C, D, and E.
That was when they came forward to make payment of the amounts and it was not paid.
That was there in there, those cases also, my lord.
Immediately.
The balance
30
amount,
ವರ್ಷ ಆದ್ಮೇಲೆ ಬಂದ್ರೆ
ಅದರಲ್ಲಿ 15 ವರ್ಷ, ನಮ್ದು ಇನ್ನೊಂದು 15 ವರ್ಷ ಜಾಸ್ತಿ.
do not find any equities in the claim of the petitioner. The petitioner cannot now claim a well-developed site after 30 years at the same allotment rate as that paid way back in the year 1994. However, since the petitioner had earlier applied for a site with respond number 1, the petitioner would be at liberty to apply for any other site in a layout found by respond number 1, where respond number 1 will be given the seniority on the basis of the earlier.
Even now, it is not, we are not forming layout itself, my lords.
Sites are available. If available, my lord.
My lords, then.
So let him apply and as per the market value.
Allala.
Are available, my lord.
Allala, sites are available andre, my lords.
If there's no other applicant, if he applies, let him pay the market value.
Let that portion may be, my lords.
In the event of applications being called for,
Yes.
for any sites to be formed or available with respond number 1, respond number 1 shall provide seniority to the petitioner on the basis of the earlier application made.
On the market value.
Needless to say that.
Yes, it has to be, my lords, otherwise.
As per the market value,
Yes, my lord, otherwise.
the prevailing market value.
Please, my lords.
5, A. Patil. Shabilamma.
This case, my lord, today, my lord, I have been informed that, my lord, there is possibility of settlement between parties in the
Get
main suit
instructions,
itself.
sir.
Both the councils
Sorry, my
submit
lord, I moved it
that.
and this is the
ಎಷ್ಟು
mode.
ದಿನ
my lord.
ಬೇಕು?
10 days, my lord.
Both the councils submit that the parties are exploring amicable resolution of the list between them. Given 10 days time, they will endeavor to report settlement. March
first week, my lord, anything.
we list
First
on
or
13th March.
Please.
Please.
6, Anandar Kolli.
Lordship, order copy is not got. Order copy is not available, sir. Need time.
Order copy?
Order copy. I number 13 is incomplete, Lordship. Lordship, I number 13 is incomplete for that.
Counsel for the petitioner seeks for and is granted 10 days time to produce a copy of the full copy of the order date 3/9/24. Relist on 13th March.
7, B. C. Gnanayi Swami.
Can it tomorrow, my lord. Tomorrow, my lord. The council.
Tomorrow agala.
Yeah.
Relist on 24th at the request of counsel for the petitioner.
8, Srinivas C.
Lord, I appear for the petitioner's counsel in this case, my Lord.
Mr. Rao?
Lord, this was heard for a while on the last occasion.
Entire order sheet in OS number 15 of 2013.
Yes.
Yes.
I have matters. If they are also produced, madam. Yes.
Not just the order sheet, you have produced a lot of documents. Kottidira?
It has been served.
Give him a copy. Kottiri, copy banta hai?
Kottidar.
Ready na?
Yes, ready.
Yes, Mr. Rao. Mr. Rao, you are on mute. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಇನ್ನ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಇದು ಮೌಸ್ ಕೊಡಿ.
ಕೊಟ್ಟಪ್ ಸರ್.
ಇಲ್ಲ ಸರ್ ಮೌಸ್ ಏನು ಮಾತಾಡ್ತಾ ಇರೋದು ಕಾಣಿಸಲ್ಲ. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಮಿಸ್ಟರ್ ರಾವ್. ವಾಲ್ಯೂಮ್ ಇದೆಯಾ? ಫುಲ್ ಇದೆ. ಅವಾಗಲೇ ಕೇಳಿಸ್ತಾ ಇತ್ತು, ಇವಾಗ ಏನಾಯ್ತು? ಚೆಕ್ ಇಫ್ ಯು ಆರ್ ಮ್ಯೂಟೆಡ್ ಯುವರ್ ಸೆಲ್ಫ್. We'll pass over the matter, Mr. Rao. By then they can adjust it. Pass over ಮಾಡದ? ಪಾಸ್ ಓವರ್ ಮಾಡೋದಂದ್ರೆ ಕೈ ಎತ್ತಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀವಿ. Yes, pass over.
Oh, bless.
Nine, Pawan, Patgeri.
Your Lordships, in this matter, there are other two petitions connected, Your Lordships.
They all can be taken.
Connect with so and so and relist and pleadings complete ಆಗಿದೆಯಾ?
Pleadings, Your Lordships, we are reporting for the settlement.
You have to accept notice.
For 2 to 5.
And AGA accepts notice for respond number
2 to 5.
2 to 5. Madam, you are appearing for respond number 1.
For number 1.
In settlement.
We are settlement, Your Lordships. We'll file it on 25th, Your Lordships.
25th.
25th.
Connect with so and so. Relist on 25th.
Yes, Your Lordships.
For reporting settlement at 2:30 PM.
Yes.
Please.
10, Srinivas K. Nadmani.
For the petitioner, my lord.
Yes.
Petitioner is praying this honorable court to issue a writ of mandamus to the respondents.
This is with regarding to formation
take
of
the
road in the
road
forest area.
ಅದೇ ಮೊನ್ನೆ ಮೂರು
No, my lord.
ಫೀಟ್.
Yes.
Your lordship may kindly see annexure D.
ಅದು ಇನ್ನೂ ಒಂದು ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾಯ್ತಲ್ಲ ಇದು.
ಈಗ ಬರೀ 30 ಮೀಟರ್ ರೋಡ್ ಅಷ್ಟೇ ಮಾಡೋದಿದೆ ಸ್ವಾಮಿ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸೀ ದಿಸ್ ಮ್ಯಾಪ್. ಓನ್ಲಿ ರೌಂಡ್ ಮಾಡಿದೀನಿ, ರೆಡ್ ಕಲರ್ ಅಲ್ಲಿ ಮಾಡಿದೀನಿ. ಓನ್ಲಿ ದಿಸ್ ಮಚ್ ಇಸ್ ಲೆಫ್ಟ್. They have.
Whose property is this?
That is government property only.
What do you have to show that it's government property?
Yes, my lord. Abutting that land, my property is there. Petitioner's property is
The
there.
abutting land is government property ಅಂತ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ? ಅವ್ರು ಹೇಳ್ತಾರೆ ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟಿ
ಇಲ್ಲ ಸರ್, ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟಿ ಇದು ಇರೋದೆಲ್ಲ ಪಿಟಿಷನರ್ದೇ ಅಲ್ಲಿ. All the properties belong to the petitioner. Adjacent land belongs to the petitioner. And one ನಿಮಿಷ. Petitioner has left out about 18 feet of land for making of this road, my lord. ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಯಾರ್ದು ಇಲ್ಲ. ಬೆಟ್ಟ ಅಂತಿದೆ, that also belongs to the government. And forest land, your lordship may kindly peruse annexure D. They have clarified there is 6 to 8 feet of wide road is there in the forest land, so there is no need for widening of the road. Annexure D, if your lordship peruse kindly, there is no requirement for widening road in the forest area.
With your private land, you can form your own road. Why do
Also,
you want them to
ನಾನೇ ಮಾಡಿದ್ದೆ ಈ 2012 ಅಲ್ಲಿ I wanted to make the road on my own cost. Annexure A ನೋಡಿ ಸ್ವಾಮಿ, annexure B ಅಲ್ಲಿ, annexure B ಅಲ್ಲಿ on 13/2/2013, annexure B,
Yes.
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ, ಸದ್ರಿ ಅವರು ತಮ್ಮ ಸ್ವಂತ ಹಣದಿಂದ ರಿಪೇರಿ ಕಾರ್ಯ ಕೈಗೊಳ್ಳಲು ಪರವಾನಗಿ ನೀಡಿದ್ದು ಅದರಿಂದ ಅಗಲೀಕರಣ ಮಾಡಲಾಗಿದೆ. ಆದರೆ ತಮ್ಮ ಊರಿನವರೇ ಆದ ಅರ್ಜಿದಾರರು ಇದಕ್ಕೂ ಅಡ್ಡಿಪಡಿಸುತ್ತಿದ್ದಾರೆ ಹಾಗೂ ಬೆದರಿಕೆ ಒಡ್ಡುತ್ತಿದ್ದಾರೆ. ಕಾರಣ ಈ ಬಗ್ಗೆ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ವಿನಂತಿಸಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಯಾವುದೇ ಪ್ರತ್ಯೇಕ ಲಿಖಿತ ಹೇಳಿಕೆ ನೀಡಿರುವುದಿಲ್ಲ. So even he is ready to spend money for making this road motorable. That's all he is
You are the
requesting.
owner of the land and survey number?
Survey number 88, 79, 80, entire extent in that 30 meters.
88, 79?
80, 78, 79, 80, 88. And also he has given up lands in survey number 103, 10, entire 103 survey number, sub survey numbers also I have stated in the writ petition. As of now, no other person, private person has any objection to that. Your lordship may kindly see also annexure.
ಊರ್ನವ್ರು ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ?
Urnor, somebody, they are not, Gram Panchayat is not clarifying who all are objecting. Your lordship may kindly see annexure H.
Where have you said about your ownership of the lands?
Ownership of the lands in writ petition, your lordship may kindly peruse page 11, para 13, my lord. The petitioner respectfully submits that the road in question is a panchayat road and the same is in use from the past 40 years or more. There are no private properties which are affected except survey number 88 of the said village, which is owned by the family of the petitioner, and they have already given their no objection and given up their land for the utility of the public, not only in the survey number but in survey numbers so and so, all these survey numbers and of Hulundi village, also for public utility without claiming any compensation, and are continuing to pay the land revenue pertaining to the said lands, my lord. Entire extent in except this 30 meters which I have marked, my lord, that is the only thing, area that need to be made motorable. That what I am asking for is not in widening also. Only make it convenient for me to take 4 wheelers there. And this is also as per annexure K. There is a government circular also to that effect. That is, there should not be any obstruction for the villagers. Page 66, my lord. This is the circular issued by the state government, wherein Rajyadalli, may I read, my lord?
Yes.
ರಾಜ್ಯದಲ್ಲಿ ರೈತರ ವ್ಯವಸಾಯದ ಉದ್ದೇಶಗಳಿಗಾಗಿ ಬಳಸುವ ಕೃಷಿ ಸಲಕರಣೆಗಳನ್ನು ಸಾಗಿಸಲು ಅನ್ಯ ಭೂಮಾಲೀಕರ ಖಾಸಗಿ ಜಮೀನುಗಳಲ್ಲಿ ತಿರುಗಾಡಲು ದಾರಿ ಸಮಸ್ಯೆ ಇದ್ದು ಬಳಕೆದಾರ ರೈತರುಗಳಿಗೆ ತೊಂದರೆಗಳಾಗುತ್ತಿರುವುದು ಸರ್ಕಾರದ ಗಮನಕ್ಕೆ ಬಂದಿದೆ. ದಾರಿ ಸಮಸ್ಯೆ ಬಹುಕಾಲದಿಂದಲೂ ಇದ್ದು ಅಕ್ಕಪಕ್ಕದ ಜಮೀನುಗಳ ರೈತರು ಕೆಲವು ಖಾಸಗಿ ಜಮೀನುಗಳನ್ನು ದಾಟಿಕೊಂಡು ಕೃಷಿ ಪೂರಕ ಚಟುವಟಿಕೆಗಳನ್ನು ಜರುಗಿಸಲು ಹಾಗೂ ಬೆಳೆದ ಫಸಲನ್ನು ಹೊರತರಲಾಗದೆ ನಷ್ಟ ಹೊಂದುತ್ತಿರುವುದು ಕೆಲವು ಮಾಧ್ಯಮಗಳಿಂದ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ ಹಾಗೂ ಈ ಬಗ್ಗೆ ಸಾರ್ವಜನಿಕರಿಂದ ಮನವಿ ದೂರುಗಳು ಸ್ವೀಕೃತವಾಗಿರುತ್ತವೆ. ಗ್ರಾಮ ನಕಾಶೆ ಕಂಡ ದಾರಿಗಳಲ್ಲಿ ಬಳಕೆದಾರ ರೈತರು ತಿರುಗಾಡಲು ಅವಶ್ಯಕವಿದ್ದಾಗ್ಯೂ ಕೆಲವು ಭೂಮಾಲೀಕರು ಬಳಕೆದಾರ ರೈತರುಗಳಿಗೆ ತಿರುಗಾಡಲು ಅಡ್ಡಿಪಡಿಸುತ್ತಿರುವುದು ಅಥವಾ ಅಂತಹ ಜಾಗಗಳನ್ನು ಮುಚ್ಚಿರುವುದು ಹಾಗೂ ರೈತರು ಬಹುಕಾಲದಿಂದ ಬಳಸುವ ದಾರಿಗಳಲ್ಲಿ ತಿರುಗಾಡಲು ಕೆಲವು ರೈತರು ಮಧ್ಯದ ವೈಯಕ್ತಿಕ ದ್ವೇಷ, ಅಸೂಯೆಗಳು ಹಾಗೂ ಮತ್ತು ಹೊಂದಾಣಿಕೆಯು ಕೊರತೆಯಿಂದ ಬಳಕೆದಾರ ರೈತರ ತೊಂದರೆಗಳಿಗೆ ಬಹುತೇಕ ಕಾರಣಗಳಾಗಿರುವುದು ಕಂಡುಬಂದಿರುತ್ತದೆ. ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ನಿಯಮಗಳು 1966 ನಿಯಮ 59ರಲ್ಲಿ ದಾರಿಯ ಹಕ್ಕುಗಳು ಮತ್ತು ಇತರೆ ಅನುಭವದ ಹಕ್ಕುಗಳು ಬಗ್ಗೆ ತಿಳಿಸಲಾಗಿದ್ದು, ಸಂಬಂಧಪಟ್ಟ ಜಮೀನುಗಳು ಭಾಗಿದಾರರು ಒಪ್ಪಿರುವಂತಹ ಸಂದರ್ಭದಲ್ಲಿ ಹಕ್ಕು ದಾಖಲೆಗಳ ರಿಜಿಸ್ಟರ್ ನಮೂದು ಮಾಡಲು ಅವಕಾಶವಿರುತ್ತದೆ. ಇಂಡಿಯನ್ ಈಸ್ಮೆಂಟ್ ಆಕ್ಟ್ 1882 ರಂತೆ ಪ್ರತಿ ಜಮೀನಿನ ಮಾಲೀಕರು ಅಥವಾ ಜಮೀನಿನ ಅನುಭವದಲ್ಲಿರುವವರು ಅವರ ಭೂಮಿಯನ್ನು ಪ್ರವೇಶಿಸುವ ಹಕ್ಕು ಮತ್ತು ವಹಿವಾಟಿನ ಹಕ್ಕನ್ನು ಹೊಂದಿದ್ದು, ಇದಕ್ಕೆ ಬಾಜುದವರಿಂದ ಯಾವುದೇ ಹಸ್ತಕ್ಷೇಪ ಅಥವಾ ಈ ಬಗ್ಗೆ ಸದರಿ.
So it has to be reflected in the village map.
Yes, my lord. Even according to the Tahsildar also, the land is in use from the road is in use from a very long time. Annexure D
Road
also
to an
they
extent
clarify
of
that
3 feet is being used.
Yes, my lord.
village map does not show more than that.
Yes, my lord.
Now you want,
What
mane with
motorable, it can be made motorable.
be connected.
How's so?
There's already a Cherakone Kodamane road.
ರೋಡ್ ಇದೆ ಅದು 30 ಮೀಟರ್ ಸ್ಟ್ರೆಚ್ ರಿಪೇರಿ ಮಾಡ್ತಾ ಇಲ್ಲ. ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿನೂ ದೇ ಹ್ಯಾವ್ ಸ್ಟಾಪ್ಡ್. ಈಗ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ವರ್ಕ್ ಆರ್ಡರ್ ಆಲ್ಸೋ annexure F ನೋಡಿ ಸ್ವಾಮಿ.
Which particular portion is not being done towards
My lord, this is the village road which is purple color, blue color. Their property comes here. Now there is an existing road of 3 feet road. That is the blue color. Now he wants for a movement to be repaired and to be done. That is with regarding to 4-wheeler.
To connect to that.
Is the connect road. This is main road is for the entire villages.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿ ಬರುತ್ತೆ?
ಅದೇ ಬ್ಲೂ ಎಂಡಿಗೆನೆ, ಬ್ಲೂ ಎಂಡ್.
ಚಾರೆಕೋಣೆ ವಿಲೇಜ್ ಅಂಡ್ ಕೋಡೆಮನೆ.
ನೀವು ಹಂಗ ಹೇಳಿದ್ರೆ ಎಲ್ಲಿ ಅಷ್ಟು ದೊಡ್ಡದಿದೆ? ಎಲ್ಲಿದೆ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ?
88 ಸ್ವಾಮಿ, ಸರ್ವೆ ನಂಬರ್ 88 ಇದರಲ್ಲಿ ಅದ್ ನಾನು ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ.
ಅಲ್ಲ ಇದರಲ್ಲಿ just now the black and white photographs with survey numbers my lord. 88 ಇದೆ.
88 79 80
68
ಅದೆಲ್ಲ ಸರ್ವೆ ನಂಬರ್ ಪಿಟಿಷನರ್ ಇದೆ ಸ್ವಾಮಿ.
ಇದ್ರಲ್ಲಿ ರೋಡ್ ತೋರಿಸಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ರೋಡ್ ತೋರಿಸಿದ್ರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ತೋರಿಸಿಲ್ಲ. ಸೊ
ರೋಡ್ ಇದೆ ಸ್ವಾಮಿ,
ಅದೇ ಅದು ಕಾರ್ಟ್ ರೋಡ್,
ಬ್ಲಾಕ್ ಅಂಡ್ ವೈಟ್ ಕಲರ್ ಇಲ್ಲ ಅಂತ. If anybody has an objection, let them hear and do, my lord. Work order was also issued. Annexure F ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ, ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
See, you are asking for a positive direct, consider ಅಲ್ಲ.
ಅಲ್ಲ,
to repair and make the road between so and so.
2013 ಇಂದ he has been, even he is ready to spend money, my lord.
Lord, here the state is not objecting insofar as usage of that property is concerned. In the government circular which they are relied, it is only when the other private persons object with regarding to the usage, then the government has directed us. We are not objecting insofar as use of that 3 feet road is concerned. He wants to repair that and to enlarge that road. That is not possible since it is comes under the forest area as per.
So that extended land comes under forest area?
ಹೌದು.
Or is it a private?
No, forest. ಅದಕ್ಕೆ
Annexure D I have produced, my lord. You will
this is the entire forest area ಇದು. ಇದರಲ್ಲಿ ಅವ್ರಿಗೆ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ರೋಡ್ ಇದೆ, ಇದು ಬ್ಲೂ ಕಲರ್ ಅದು.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಬರುತ್ತೆ?
ಅಲ್ಲ, ಆ ಸರ್ವೆ ನಂಬರ್ ಅದು ಇನ್ನೊಂದು just now handed over black and white ಫೋಟೋ ಕಾಪಿ ಆಫ್ ದ ಗೂಗಲ್ ಮ್ಯಾಪ್.
88 ಅಲ್ಲಿ ಇವ್ರ ಮನೆ ಇರೋದು.
ಹೌದು, ಇಲ್ಲಿ
ಇದು ಸರ್ವೆ ನಂಬರ್ 262 ಫಾರೆಸ್ಟ್
ಲ್ಯಾಂಡ್. ಇಲ್ಲಿಂದ ಇಲ್ಲಿ ಮಠ ಇದೆ. ಈಗ there is an existence road up to his property. That is blue color in the color photo. Blue color. Adರಲ್ಲಿ property numbers are not mentioned, but I have given this copy, my lordships.
So the road goes from 88 to
up to our property ಮಟನೂ ಇದೆ.
88 ಇಂದ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಮೇಲೆ ಹೋಗುತ್ತೆ?
ಇದು 66 ಆಮೇಲೆ 90 ಸರ್ವೆ ನಂಬರ್ ಇಂದ ಹೋಗುತ್ತೆ.
90.
ಹೌದು, 90 68 and 87 88 ಅಲ್ಲಿ ಆಜು ಬಾಜು ಇದಾವೆ.
68 90 87.
Yes.
87 68 90 are forest land.
ಹೌದು, ಸುತ್ತಲೂ ಇದು ಎಂಟೈರ್ ಏರಿಯಾ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್. ಹೇರ್ ಮೈ ಲಾರ್ಡ್ ಓನ್ಲಿ ಸರ್ಟನ್ ತೋಟ ಇದಾವೆ ಇಲ್ಲಿ ಆ ರೋಡಿಗೆ ಹಚ್ಚಿ. ಅದು ಕೊಟ್ಟೆನಲ್ಲಿ. I have secured the original entire village map. If the lordships can see that, if it is possible.
What Mr. Gopal Krishna, what you had said was that you are willing to give your family and yourself are willing to give up 79, 80, 78.
Yes, ma'am.
78, 79, 80 ಇಲ್ಲೆಲ್ಲೂ ಕಾಣಿಸ್ತಾನೆ ಇಲ್ವೇ?
Abutting that entire, all these survey numbers are abutting the road.
ಇಲ್ಲಿ ಬರುತ್ತೆ ಇದು 79, 80, 78, 79, 80.
ಅದು ನಾನು ಫಾರೆಸ್ಟ್ ಅವರು ಆಲ್ಸೋ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Annexure D have produced. They are saying Annexure D page 44. They say in their area it is 6 to 8 feet wide, so no need to widen the road there. Last para, my lord. ಕುಲ್ಲುಂಡೆ ಗ್ರಾಮ ನಕಾಶೆ ಹಾಗೂ ಗ್ರಾಮ VFR ಅನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ರಸ್ತೆ ಇರುವ ಬಗ್ಗೆ ಯಾವುದು ನಮೂದು ಇರುವುದಿಲ್ಲ. ಆದರೆ ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ದಾಖಲೆಗಳಲ್ಲಿ ಕಾಲುದಾರಿ ಬಗ್ಗೆ ದಾಖಲಾತಿ ಇರುವುದಾಗಿ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಹೆಗ್ಗರಣೆ ಇವರು ದಾಖಲಾತಿ ಪತ್ರ ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ಅರಣ್ಯ ಸರ್ವೆ ನಂಬರ್ 262ರಲ್ಲಿ 80 ಮೀಟರ್ ಉದ್ದ ದಾರಿ ಸಾಗಿದ್ದು ಈಗಾಗಲೇ 6 ರಿಂದ 8 ಅಡಿಯಷ್ಟು ಅಗಲ ದಾರಿ ಇರುತ್ತದೆ. ಇಲ್ಲಿ ಸದರಿ ಅರಣ್ಯ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ರಸ್ತೆಯನ್ನು ಅಗಲೀಕರಿಸುವ ಅವಶ್ಯಕತೆ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಬೆಟ್ಟ ಸರ್ವೆ ನಂಬರ್ 104 226 ಮಾಲ್ಕಿ ಸರ್ವೆ ನಂಬರ್ 88 ರಲ್ಲಿ ಹಾನಿಯಾಗದಂತೆ ಇರುವ ಸ್ಥಳಾವಕಾಶವನ್ನು ವಾಹನ ಚಲಿಸುವಂತೆ ಬಳಸಿಕೊಳ್ಳಬಹುದಾಗಿರುತ್ತದೆ. They only admit, my lord. Forest.
We'll appoint the dealer to get a proper.
The entire village map. Lord, that brown color is betta, ಎರಡು side. Center white portion is the Malki property and green color shown is the forest areas.
ಇವ್ರದಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ
ಅದು just a center a portion. Last 88 ಬರುತ್ತೆ.
Right side ending.
And beside that is that road.
Yes, ma'am.
What is the width of that road?
3 feet.
ಕಾಲುದಾರಿ.
ಹೌದು.
So apart from that 3 feet road, they don't have any access?
No.
Rest of it is forest land?
Yes. And there is a general road which is as per the Google map.
General road ಹೋಗಕ್ಕೆ access ಇದೆ?
ಅದು access ಅಂದ್ರೆ main road ಇದೆ. That is purple color which has been shown in the Google map. This is the common road which has been utilized by the entire village. Purple color road.
ಇವ್ರ ಮನೆ ಎಲ್ಲಿ ಬರುತ್ತೆ?
ಅವ್ರ ಮನೆ ಫಸ್ಟ್ ಗಿನೇ ಇದೆ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿ.
This red color is there?
Yes. ಹೌದು.
So this purple road is?
ಇಲ್ಲಿ ಕಡನ್ ಮನೆ ಅಂತ ಇದೆಯಲ್ಲ, that is the property of the petitioner. From there my lord blue color starts.
This purple road is what is the width of
that
it?
It is used for the entire village. That is width, my lord. Public road. It is a public road. Purple color road is used for public road for transportation and other things is concerned.
You want a shortcut?
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಅದು ಆಲ್ರೆಡಿ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ರೋಡ್ ಇದೆ, ಅದು ಬ್ಲೂ ಕಲರ್.
ಇಲ್ಲ, ಅದು ಅದರಲ್ಲಿ ವೆಹಿಕಲ್ ಹೋಗಕ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ. 4-wheeler cannot be taken.
ರೋಡ್ ಅಲ್ಲಿ ವೆಹಿಕಲ್ ಓಡಾಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ, that will not connect me
to his field.
Your field purple road ಅಲ್ಲಿಗೆ ಇದೆ ಅಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಿಲ್ಲ, ಅಲ್ಲಿ ಹೋಗಕ್ ಆಗೋದೇ ಇಲ್ಲ ಅಂತ
ಅಲ್ಲಿ ಬರುತ್ತೆ ಅವ್ರದ್ದು. ಬ್ಲೂ ಕಲರ್ ಎಂಡಿಗೆ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಬರುತ್ತೆ.
ಇಲ್ಲಿ ನೀವು your mark here red color.
That is his house.
Applicant's house.
House. So he wants that road to connectivities to his farm, to his agriculture land. That there is an existence road of 3 feet road. That is blue color which is marked. Now he wants that 4-wheeler transportation has to be done and it has to be expanded.
This motorable ಮಾಡ್ಕೊಟ್ಟು ನಾವು expansion ಏನಕ್ಕೆ ಕೇಳ್ತಾ ಇಲ್ಲ. Let it be made motorable, my lord, because that is I am unable to access.
ಇನ್ನೆಷ್ಟು ಜನದ ಲ್ಯಾಂಡ್ ಇದೆ?
ಇವ್ರಿಗೆ ಒಬ್ಬರದೇ ಹೋಗ್ತಾ ಇರೋ ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲಿಗೆ ಇರೋದು, ಇವ್ರು ಒಬ್ಬರದೇ ಉಳಿದವರು ಅದರ್ಸ್ ಆರ್ ನಾಟ್ ಆಬ್ಜೆಕ್ಟಿಂಗ್ ಇನ್ ಸೋ ಫಾರ್ ಆಸ್ ಯೂಸ್ ಆಫ್ ದೇರ್ ಪ್ರಾಪರ್ಟೀಸ್ ಕನ್ಸರ್ನ್.
ಮಾಡಿದ್ರೆ ಅವರು ಬರ್ತಾರೆ.
ಮತ್ತೆ ಬರ್ತಾರೆ. It will be flooded open.
Now even I propose to spend from my pocket and make this road.
People are ready to spend to take away the forest.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಫಾರೆಸ್ಟ್ ಇಲ್ಲ, annexure D ನೋಡಿ ಸ್ವಾಮಿ, ಫಾರೆಸ್ಟ್ ಅಲ್ಲಿ ನಾವು ಕೇಳ್ತಾನೆ ಇಲ್ಲ.
If this is a forest land, we are
not forest land. ಅವರೇ annexure D
RTC ನೀವು ಸರ್ವೆ ನಂಬರ್ ಹೇಳಿ, ಆವಾಗ ನಮ್ಮ 4 ಸತಿ ಕೇಳಿ ಆಯ್ತು, ನೀವು ಹೇಳಲ್ಲ ಅಂತ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಈಗ annexure D ಅಲ್ಲಿ ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ has given an address.
ನಮಗೆ ಬೇಡ. What are the survey numbers in which this road follows and where is the RTC for those survey numbers? If it is forest, we are not going to touch it.
RTC ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
You have 3 feet road or no road?
ರೋಡ್ ಇದೆ. ಆಯ್ತು. annexure A series I have produced this RTCs relating to the land. Survey number 78,
79.
First survey numbers ಹೇಳಿ.
ಅದೇ
78 ಇದೆ ಸ್ವಾಮಿ.
78, 79,
80
ಎಲ್ಲ ಸ್ಮಜ್ ಆಗಿ.
84,
88,
88, 89.
89.
ಯಾವ್ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಹೇಳಿ ನಿಮ್ಮ
78 ಸ್ವಾಮಿ 78 78 79
80,
80
88, 89.
84 88 ಆಮೇಲೆ 89 ಸ್ವಾಮಿ 87 88 87 88 89.
Your agricultural land is in 103.
ನೋ ಇಲ್ಲೂ ಇದೆ ಸ್ವಾಮಿ, ಅಲ್ಲೂ ಇದೆ, ಅದು ಬೇರೆ ರೋಡ್. ಅಲ್ಲೂ ಬಿಟ್ಟು ಕೊಟ್ಟಿದೀವಿ ನಾವು, ಅಲ್ಲೂ ಬಿಟ್ಟು ಕೊಟ್ಟು ರೋಡ್ ಮಾಡಿಸಿದೀವಿ.
ಇವಾಗ ನಿಮ್ಮ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಯಾವ ಸರ್ವೆ ನಂಬರ್?
ಈ ಸರ್ವೆ ನಂಬರ್ ಇದೆ, ಈ ಕೊಟ್ಟು ನಾ ಮೆನ್ಷನ್ ಮಾಡಿದ್ನಲ್ಲ 79 ಆಲ್ ದಿಸ್. ಹೌದು ಸ್ವಾಮಿ.
79 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? 79 ಇದ್ರಲ್ಲಿ ತೋರ್ಸೇ ಇಲ್ಲ.
Please.
Where is 79?
ಇಲ್ಲ ಅದು ಒಂದೇ ಐತ್ರಿ ಮ್ಯಾಪ್ ಅದ್ ನಾವು.
ಅನೆಕ್ಷರ್ ಎಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ಸ್ ಮೆನ್ಷನ್ ಆಗಿದೆ.
ನೀವು ಸರ್ವೆ ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡೋದಕ್ಕೂ ಪ್ಲಾನ್ ಅಲ್ಲಿ ತೋರ್ಸೋದಕ್ಕೂ ಬಹಳ ವ್ಯತ್ಯಾಸ ಇದೆ. From that time you are not able to show us anything except to say 3 feet ಇದೆ, ಅದೊಂದು ಮಾತ್ರ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
ಅನೆಕ್ಷರ್ ಎಲ್ ಅಲ್ಲಿ
as to where your this one is.
ಅನೆಕ್ಷರ್ ಎಲ್ ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ, ಅನೆಕ್ಷರ್ ಎಲ್ ಪೇಜ್ 68.
Yes.
ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ಸ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ 80 81 82. ಸರ್ವೆ ನಂಬರ್ಸ್ ಎಲ್ಲ ಮೆನ್ಷನ್ ಆಗಿದೆ. ಅಬೌಟಿಂಗ್ ದ ರೋಡ್ 89 ಇದೆ, 82 ಇದೆ. ಆಲ್ ದಿ ಸರ್ವೆ ನಂಬರ್ಸ್ ಆರ್ ದೇರ್.
We'll appoint the ADLR to do this and give us the proper survey.
Please.
The grievance of the petitioner is a petitioner house is situated in survey number
103.
88.
No.
No, my lord.
House is not situated there.
That's agricultural land, my lord.
Land only.
House ಯಾವ survey
ಹೌದು, ಅದು 103 ಕಡೆ ಅಂತ ಇದೆಯಲ್ಲ, ಮಾರ್ಕ್ ಮಾಡಿ.
103. ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ.
ಅನೆಕ್ಷರ್ ಎಲ್ ನೋಡಿ ಸ್ವಾಮಿ, ಕ್ಲಿಯರ್ ಆಗಿ ಗೊತ್ತಾಗುತ್ತೆ. ಅನೆಕ್ಷರ್ ಎಲ್ ಅಲ್ಲಿ
ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ ನಿಮ್ ಕೇಳ್ತಾ ಇರೋದು.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಅನೆಕ್ಷರ್ ಎಲ್ ನೋಡಿದ್ರೆ
ಎಲ್ಲಿದೆ ಹೇಳಿ.
ಹೌಸ್ ಈಸ್ ಆನ್ ದಿ ಮೇನ್ ರೋಡ್. ಈಗ ಮೇನ್ ರೋಡ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಪ್ಪ?
ಸರ್ವೆ ನಂಬರ್ ಸರ್ವೆ ನಂಬರ್
ಸರ್ 103. 103 ದಲ್ಲಿ
ಮೇನ್ ರೋಡ್ ಅಲ್ಲಿ ಇದೆ.
103 ದಲ್ಲಿ ಮೇನ್ ರೋಡ್ ಬಾಜು
ರೋಡ್, ಇಲ್ಲಿ ಮೇನ್ ರೋಡ್ ಒಂದಿದೆ ಮುಂದ್ಗಡೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಅನೆಕ್ಷರ್ ಎಲ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ ಕ್ಲಿಯರ್ ಆಗಿ.
ಧಾರವಾಡ ಬೆಳಗಾಂ ಮೇನ್ ರೋಡ್,
ಇದ್ರಲ್ಲಿ
ಪುನಾ ಮೇನ್ ರೋಡ್ ಅಂತ ಹೇಳ್ಬೇಡ.
ಇದರಲ್ಲಿ ಮೇನ್ ರೋಡ್
ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಬೇಕು ನೀವು. even if you have a case you lose it because you are not able to tell us that.
Yes, ಸರ್ವೆ ನಂಬರ್
only reason why we are hearing you is because you are saying that you are not don't have a ಇಲ್ಲ ಯಾವಾಗಲೂ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾ ಇದ್ದಿದ್ದು.
ಇಲ್ಲ ಸರ್, not that. My apologies.
In which survey number is your house?
House exactly ಇದು ಹೌಸ್ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಬಟ್ ಇಟ್ ಇಸ್ ಶೋನ್ ಆನ್ ದಿ ಅನೆಕ್ಷರ್ ಎಲ್. ಇಲ್ಲಿ ಡಾಟ್ಸ್ ಮಾಡಿದಾರೆ.
ಮನೆಯಿಂದ ನಿಮ್ ಪ್ರಾಪರ್ಟಿಗೆ ಆಕ್ಸೆಸ್ ಬೇಕಾ? ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಬೇಕು?
ಮನೆಯಿಂದ ಮೇನ್ ರೋಡ್ ಇಂದ ಆಕ್ಸೆಸ್ ಬೇಕು ಸ್ವಾಮಿ. ಮೇನ್ ರೋಡ್
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಇದೆ?
ಇಟ್ ಈಸ್ 101 102. ಇಲ್ಲಿ ಅನೆಕ್ಷರ್ ಎಲ್ ಅಲ್ಲಿ ದೇರ್ ಆರ್ 2 roads.
ನೀವು ಸರಿಯಾಗಿ at this rate, even if we direct the ADLR, you won't be able to give us any report. Correct ಆಗಿ ತಿಳ್ಕೊಂಡು ಹೇಳಿ. Yes.
The present petition is filed by the petition being aggrieved by the endorsement issued by the respondent number 5 Tahsildar for the permission to alienate the granted land in the year 2000, lordship. That was a 15 years locking period as per the Hakkupatra that is been issued in favor of the petitioner, lordship. At the annexure A is the application filed by the petitioner at the page number 19, and it was been considered and the land was granted to an extent of 2 acres 22 guntas
Yes.
in favor of the petitioner in the year 2001.
Hmm.
And there was a condition saying that 15 years should not be not alienated.
Yes.
And in 2024, he filed an application for the permission to alienate the land.
2001 allotment ಅಂದ್ರೆ 2026 ವರೆಗೂ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ?
No, he was doing the agricultural activity. Now he,
There's an embargo for 15 years.
yes.
So you wait for another year.
2000.
2001,
2001, it was been granted. Now it is 2025, Lordship. 24ರಲ್ಲಿ ನಾವು 24ರಲ್ಲಿ ನಾವು 15 years. Now it has been, and there was a condition also.
Really, where is this endorsement?
My lord, annexure H, page number 58. And my lord, there was a condition in that one. The granted made in favor of the petitioner was challenged by his relatives, who was nowhere relevant. And the matter was challenged before the Karnataka Appellate Tribunal. Appellate Tribunal is remanded back, asked to conduct the fresh inquiry, giving the notice. And the respondent number 3 passed an order and confirming the land granted in favor of the petitioner in the 2001. Whatever is correct, that is correct. That is the order is there at the page number 39, annexure F. They are considering the date from this particular date, which was been reconfirmed by the respondent number 3. After that, there is no Hakkupatra, nothing was been issued.
After this, there is no challenge.
There is no challenge at all. My lord, in RTC also, there was a 15 years locking period till 2022. After that, they have removed it. Lordship permit, I may be permitted to pass on those RTC copies.
It's back to the original allotment.
Yes.
But after litigation, you can't extend it by another 15 years.
No, page 55 may kindly be seen.
55.
Yes.
Yes.
Operative portion of the order. ಕುಮಟಾ ತಾಲೂಕಿನ ಗೋಕರ್ಣ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಶ್ರೀ ಗಣಪ್ಪ ಗೌಡ ಇವರು ಸನ್ 73-74 ಪೂರ್ವದಿಂದಲೂ ಸಾಗುವಳಿ ಮಾಡುತ್ತಾ ಬಂದಿರುವುದೆಂದು ಮತ್ತು ಸದರಿಯವರು ದತ್ತಕ ಮಗ ಶ್ರೀ ಚಂದ್ರ ಗೌಡ ಇವರು ತಿದ್ದುಪಡಿ ಕಾಯ್ದೆ ಜಮೀನ್ ಮಂಜೂರಿ ಕೋರಿ ನಮೂನೆ 7ನೇ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ರಿಂದ ಹಾಗೂ ತಹಶೀಲ್ದಾರ್ ಕುಮಟಾದವರು ಸ್ಥಳ ಪರಿಶೀಲನೆ ವರದಿಯಂತೆ ಹಾಗೂ ಹಿಂದಿನ ಸಹಾಯಕ ಆಯುಕ್ತರ ಕುಟುಂಬ ಕುಮಟಾದವರು ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 12/12/2000 ಶ್ರೀ ಚಂದ್ರ ಗೌಡ ಇವರು ರಲ್ಲಿ ಒಟ್ಟು ಕ್ಷೇತ್ರ 11 ಎಕರೆ 22 ಕ್ಷೇತ್ರದಲ್ಲಿ 2 ಎಕರೆ 22 ಮಾತ್ರ ಸ್ವಾಧೀನ ಹೊಂದಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿರುವುದರಿಂದ ಕುಮಟಾ ತಾಲೂಕಿನ ಗೋಕರ್ಣ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಕ್ಷೇತ್ರದಲ್ಲಿ 11-22 ಕ್ಷೇತ್ರ 2 ಎಕರೆ 22 ಜಮೀನು ಈ ಚಂದ್ರಗೌಡ ಇವರನ್ನು ಅಧಿಭೋಗದಾರನಾಗಿ ಪರಿಗಣಿಸಿ ಮಂಜೂರು ಮಾಡಿ ಆದೇಶಿಸಿದೆ. This was passed on 3/7/2017 at the bottom.
Yes, Lord.
Date.
Yes.
So based on this, my lord, the impugned endorsement which says that since there is a condition that 15 years is not completed, so that endorsement has been issued. So he has been declared as a tenant from
the
earlier order is at page number 27, annexure C.
That is
Hakkupatra, and the order is at the page number 23.
26.
What survey number was it?
1494. 1494.
ಕ್ಷೇತ್ರ 2 ಎಕರೆ
22.
Same.
So my lord, again it backs go to that in view of this.
ಈಗ ಲಿಟಿಗೇಷನ್ ಆಯ್ತು ಅಂತ ಹೊಸ ಡೇಟ್ ಫಿಕ್ಸ್ ಆಯ್ತು
ಅಲ್ಲ ಹೊಸ ಡೇಟ್ ಅಂತಲ್ಲ, ಯಾಕಂದ್ರೆ ಈ ದಿವಸದಿಂದ ಅಧಿಭೋಗದಾರರು ಅಂತದ್ದು ಇದಾಗಿದೆ.
ಇದು ಚೇಂಜ್ ಇನ್ ದಿ ಏರಿಯಾ ಅಟ್ ಲೀಸ್ಟ್ ಏನೋ ಒಂದು
ಎಸ್
ಇತ್ತು, ಅದು ಏನು ಚೇಂಜ್
ಆಗಿಲ್ಲ.
AG accepts notice.
ಅಲ್ಲ ಆಗಿದೆ
Respondent number 1
that has been already on the last occasion.
Petitioner is before this court seeking for the following reliefs. The petitioner claims to be a permanent resident of Gokarna village, Kumta Taluk, Uttar Kannada district. The petitioner family claimed to be in possession and cultivation of land bearing survey number 1494, measuring 11 acres 22 guntas in the aforesaid village, and made an application in form number 7A on 19/1/1999. The claim of the petitioner's forefathers was rejected, was partly allowed to an extent of 2 acres 22 guntas, while order dated 22/12/2000, and Hakkupatra came to be issued on 2/7/2001. This Hakkupatra was challenged by
the relatives of the petitioner.
Some of the relatives of the petitioner in revision petition number 358 of 2006. Which came to be disposed Annexure D ಏನಾಯ್ತು?
Matter remanded back to the Assistant Commissioner to consider by giving the suitable opportunity to the appellants.
That is at page 37.
Which came to be disposed by order dated 17/7/2009. The allotment on 12/12/2000 was set aside and matter remitted. Was set aside.
Is set aside and remitted back. Page 36.
Yes, Lord.
KAT order.
So set aside ಅಂದ್ರೆ first time ನಿಂದ ಮತ್ತೆ allotment ಆಗಿದೆ 2017.
Now, but there is no ಹಕ್ಕುಪತ್ರನೇ issue ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಅದು ಬರಕ್ಕಾಗಲ್ಲ.
That is the only.
But allotment has been set aside.
Yes, Lord. That is as per
Yes,
the
we can
KAT order that is been, but they in the order that is impugned order, they reconfirmed whatever the 2000 in that operative position, the R3 reconfirmed that. Whatever the we earlier granted.
Aside ಮೇಲೆ reconfirm ಬರಲ್ರಿ, ನಿಮ್ fresh allotment ಆಗುತ್ತೆ.
39 ಅಲ್ಲಿ annexure F ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ ಅವರು ಈ 2000 ಇಸ್ವಿಯಲ್ಲಿ ನಾವು ಏನು AC ಮಾಡಿದ್ರು.
Was set aside and matter remanded to the Assistant Commissioner, Kumta Subdivision. Upon such remittal, wide order dated 3/7/2017, the claim made by relatives of the petitioner was rejected. And the claim was confirmed to 2 acre 22 guntas wide the order dated 3/7/2017 at annexure F. Subsequent thereto, the petitioner made an application for sale of the said land on the ground that the prohibitory period of 15 years from the date of issuance of the Akkupatra had expired. The said request came to be rejected wide order dated 6/12/2023 at annexure H, containing that the allotment, the allotment having been made on 3/7/2017, subsequent to the allotment having been set aside, the period of 15 years has not expired, and as such, no sale permission could be granted. It is challenging the same. The petitioner is before this court. The submission of Sri Vinay Bhatt, learned counsel for the petitioner, is that the Akkupatra having been issued on 2/7/2001, 15 years expired on 1/7/2016, and as such, the permission ought to have been granted. Learned AGA would however submit that the order dated 2/7/2001 was set aside by the KAT in revision petition number 358 of 2006, and the matter remitted to the Assistant Commissioner for fresh consideration. Thus, as on 17/7/2009, when the KAT passed the order, his submission is that the allotment having been cancelled, there is a fresh allotment made by the Assistant Commissioner wide the order dated
3/7/2017.
3/7/2017, and that's the embargo of 15 years, the prohibitory period of 15 years would have to be considered from 3/7/2017 and not from the initial issuance of the Akkupatra on 2/7/2001. Heard so and so peruse papers. The present matter is one where the Akkupatra, though issued on 2/7/2001, was cancelled wide order dated 17 July 2009 by the Karnataka Appellate Tribunal, and subsequently on remand, the Assistant Commissioner confirmed the said allotment wide its order dated 3/7/2017. The proceedings.
DC, district, additional district. Appara.
The proceedings which have taken place are in continuation of each other and not as separate proceedings. The initial application made had been granted in favor of the petitioner. A challenge having been made, this challenge succeeded and the allotment was set aside. And thereafter, on remand, allotment was confirmed in favor of the petitioner. Thus, the date of allotment would date back to the initial allotment, that is 2/7/2001, and cannot be said to be a fresh allotment made on 3/7/2017 as contended by respond number 5. Five. In that view of the matter, the endorsement issued not being in accordance with law, I pass the following order. Writ petitions allowed, a certiorari is issued, the endorsement dated 6/12/2023, issued by respond number 5 at Annex H is hereby quashed. The respondents are directed to consider the representation dated 11/5/2022 submitted by the petitioner by considering the original date of allotment to be the date of issuance of the Akkupatra, that is 2/7/2001, and pass necessary orders thereon within a period of 30 days from the date of receipt of a copy of this order.
Much obliged.
12, Prithvi case.
Lord, in this, on the last occasion, the Lordship has directed me to ascertain whether the extent of land, that is about nearly 100 acres of land, is not fit for cultivation for agriculture. But today morning, I have received the information. Today morning, the concerned officer has approached, and I had to further clarify and make submission.
Pass over,
Pass on, please.
My lords, we are the allottees of the land, my lords, here, and we are not made the parties to the case, my
You're
lords.
the allottees.
On that, my lords, I will submit, my lords.
Totally 48
Lordship pass
allottees,
over.
my lords.
If
And
the
today,
allottees under what act?
my lords, by virtue of the order passed by the Assistant Commissioner, we have not yet received any of the documents, my lords. Today morning itself, the parties have approached us. And there are totally 48 allottees, out of which more than 15 of them have approached us, my lords. So request for a time, my lord, short.
That order, my lords, I have
time,
produced.
8 to 10 days time, my
Annexure
lords.
H is the.
Annexure H, my lords, I have produced. There, my lords, the deputy commissioner, my lords, has not passed any order. It is the, my lords, power has been assigned to the deputy commissioner as per rule 26B.
This is your land is what your claim is.
My lords,
Did the allottees come in?
allottees, my lords, during the pendency of writ petition, that was also stated by the assistant commissioner that our writ petition is pending before this honorable court. By stating that also, my lords, on the recommendation, my lords, of the deputy commissioner, he has passed an order.
When was that order passed?
My lord, that order passed in the year 2007, my lords, wherein our writ petition was disposed of in the month of, my lords, on 3/1/24. Our order,
They'll have to come on record, we'll have to hear them.
and that in that order, my lords, there is no, my lords, order of deputy commissioner for allotting. That is, he is having the.
Let them come on record, we'll have to hear.
Please, please.
Please, my lords.
So and so submit that should be filing an impleading application. When will you file?
8 to 10 days, my lords, time. My lords, I have
Well,
not yet
one
received the
will do,
document.
Today itself, I will make party.
Application akka gattina be.
Week's time, I kindly be
Takes for a week's time to file an impleading application. Relist on 24th.
Please.
obliged.
13, Rajshekhar Burji.
On the last occasion, my lords directed the government, my lord, to ascertain, my lord, whether the property of the petitioner was acquired and the compensation is paid. My lord.
Yes.
Your Lordship, I undertake to file wakalat on respond number 7, Your Lordship.
Yes.
I undertake to file wakalat.
Lord, this honorable court has directed me to take notice. Lord, that has been entrusted to Prashant Vasmani. He wanted to file wakalat.
Let them file wakalat. But then if you are going, asking time or are you making a,
Asking time, Your Lordship.
then you don't construct anything till the next date. Purpose of giving that direction is not to engage another council. That is bound, ನಿಮ್ಗೂನು ಅಷ್ಟೇ. ನಿಮ್ಗೆ ಹೇಳಿದ್ರೆ ಅವ್ರಿಗೆ ಹೋಗಿದೆ. They can't do all that and escape. Prashant Vasmani submits that he would be filing wakalatnama for respond number
7, Your Lordship.
4 and 7.
4 and 7, my lord.
Registry is direct print his name as such and delete the name of Shri
S.C.
Bhuti as that as appearing for respond number 4 and 7. The respondents are restrained from putting up construction. Any further construction in survey number 385/*3 of Beur village, Yelaburga Taluk, Koppal district till the next date of hearing. Since the learned counsel for respond number 4 and 7 seeks for a short accommodation to make a submission as regards the order dated 6/2/2025.
One
Relist
submission.
on-
Sorry for the interruption. But I wanted to file an application for impleading. They have not made me as a party. I'm the contractor. Case
Only.
has entrusted the work. I have already started the
Your
construction.
contract, as a contractor, you have no right more than what they have.
No, but thing is now, my lord, they kindly peruse, my lord. Almost work, my lord, is.
ಅಕ್ವಿಸಿಷನ್ ಮಾಡಿದೀರಾ ಇಲ್ಲ ಅದ್ ಹೇಳಕ್ ರೆಡಿ ಇಲ್ಲ
They have
ಯಾರು.
to tell, my lord, but now as a contractor, I have invested and bus stand being constructed. for
Saukar,
the
you have
public.
no right more than them.
Yes, that I.
You can claim damages.
My lord, one submission in this case. The father of the petitioner herein has handed over this property for the construction of the inspection bungalow. It was in existence for the last 30 years. Now, since that inspection bungalow is not having been used, now it is utilized for the purpose to establish
Document.
my lord, photographs and other things. Allah, aduk one submission. The question of the lordships, there is no acquisition proceedings as on today. That is admitted fact.
Gift idre gift kodi.
Illa adu illa.
ಮತ್ತೆ
That was an oral which has been entered agreement. There is no acquisition proceedings which has been initiated. Now the petitioner kept quiet for the last 30 years. After completing the demolition of the entire inspection bungalow, he approached this court seeking compensation since that land is vacant and he is entitled for compensation under the new act. So my lord, he is entitled. It is property. It is an admitted fact. We are not disputing that he is not the owner of that property. Now my lord, acquisition proceedings is not initiated as also on today, but since in view of handing over of that demolishing and handing over to put up the bus stand in the interest of the public, steps have been taken, but he is entitled for compensation.
So should we record your statement that you will be giving
Yes, this
compensation?
information is given on the basis of the instructions given by the
File an affidavit.
yes,
File an affidavit. ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ?
next Monday, my lord.
Please. Until then, no construction.
Please,
Released on 24th at 2:30 PM.
please.
Till then, my lord,
See, the whole problem is without acquisition,
How?
it may be a good intention. Road ಮಾಡ್ತೀರಾ, bus stand ಮಾಡ್ತೀರಾ, ಏನ್ ಮಾಡ್ತೀರಾ?
public purpose, he has invested, my lord,
Public purpose cannot be taking a private land without.
acquisition, that is right, but ultimately if he is entitled for compensation.
Well,
he has to
ultimately,
be-
ಕೊಡ್ತೀರಾ ಅವ್ರಿಗೆ?
No, I am as a contractor, but I am unable to.
ಹೌದು, I am a contractor.
Now, the KSRTC has executed agreement in my favor.
Wait till next week.
But till then, my lord, at least
No construction.
subject to result of the writ petition,
No
because
construction.
he has invested.
No
my lord, huge-
construction, Ms. Saukar. Nothing at all.
ಸಂಗಮೇಶ್ ಗುಳಪ್ನವರ್.
ಇನ್ನ ಅವ್ರ ಅಫಿಡವಿಟ್ ಹಾಕ್ತಾರೆ ಅಂತ ನಮ್ಗೆ ಇನ್ನ ಇದಿಲ್ಲ. ಅದು ಅಫಿಡವಿಟ್ ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನೇನ್ ಮಾಡಿದ್ರು ಅದನ್ನು ಡೆಮಾಲಿಷ್ ಮಾಡಿಸ್ತೀವಿ. 14.
For response, my lord.
Yes.
The trial court, without issuing the notice to the LRs of the respond number 6, A to H.
ಬರೀ
my lord.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಗ
Respond number 1 is the plaintiff, my lord. Only contesting the respond number 1. He filed FTP.
That is also respond number 1. Defend number 4. Yes, Eddie.
Impugn order is page number 130, my lord.
Suit
Annexure
for?
H. Suit for partition and separate possession, my lord. Suit was partly decreed, my lord. The 1/8 share was allotted to the plaintiff, my lord. Against that, my lord, the defendants has prepared the appeal before the lower court, appellate court, my lord.
Yes.
The lower court has the notional award has passed. The notional share was allotted to the plaintiffs and only. The against that order, my lord, the plaintiff has prepared RSA. RSA has the allowed, my lord, and modified the trial court order. Is 1/7 share was passed, granted, my lord.
It shows the document, shows the
Page,
orders.
page number 16,
Initial judgment and release.
first page. Annexure A, my lord, OS judgment.
Suit of the plaintiff is decreed. Are entitled to 1/8 share each.
1/8 share.
Yes. RALE?
RALE notional share was awarded to the last operative question, page number 47, my lord.
To 1/7 ಆಯ್ತು.
Yes, my lord. RSA was confirmed, my lord. Same order was made. Against that, my lord, the defendants has prepared the SLP, my lord. SLP has dismissed and confirmed the judgment part. Against that, my lord, the respond number 1 has filed FDP.
See, 28 March.
FDP petition. During the pendency of FDP, my lord, respond number 6 was died, my lord. The application was filed. Lower court, without issuing the notice, The IA number 11 was allowed, my lord.
What is I 11?
Yes, my lord. The page number 130, my lord. In annexure H, my lord. The appointment of court commissioner, my lord, IA number 11. Before that, my lord, page number 130. Kindly permission to read, my lord.
Yes.
After perusing the order sheet, it appears that the notice to the respond number 6A to 6H issue on dated 3/8/2024. Letter due to oversight, the notice was not issued. Letter as per the order of the Honorable High Court of Karnataka for the modification of the decree, the counsel for the application filed application which is allowed, and letter the IA number 11 was filed by the appointment of court commissioner, in which our counsel for the petitioner filed memo stating that the legal heirs respond number 6, that is 6A to 6H, having equal share, that is 1/7. Hence, if the application is allowed, the appointment of court commissioner, no prejudice caused to the legal heirs of the respond number 6. Hence, this IA number 11 is allowed, madam.
Who are you?
I am the dependent, my lord.
You are defendant number 4.
Yes, my lord.
You are not respond number 6.
Yes, my lord. I have filed the objection to the said IA, my lord.
What is your objection?
The LLRs of the respond number 6 has not issued notice to the. He is also shareholder of the joint property.
They have not come forward.
Yes, my lord. But they are the necessary parties to this court, my lord.
You are only wanting to delay the matter, nothing else.
Yes, my lord. We are the taken contention before the court, my lord.
Yes, sir,
Only he is also shareholder, my lord. Response 6 is the party to the all proceedings, my lord.
He is a party, they have been entitled to 1/7, there is no
Yes,
particular
yes.
change.
Yes, my lord.
There is nothing which is going to affect them. Why are you filing objections?
No, but without issuing, he is also shareholder of the.
It is for them to come and say.
They only issue notice to the response 6, my lord.
ನೀವು
Necessary in this case, my lord.
ಯಾಕ್ರಿ 6 ಬೇಕಲ್ಲ?
My lord, in
But
this case,
earlier
we
page
are
number-
not denying the share of the respond number 6, my lord.
But meets and bounds commissioner appoint ಆಗಬೇಡ್ವೇನಪ್ಪ?
But my lord, in this case,
How 1/7 share decide ಮಾಡ್ಬೇಕು ತಾನೆ?
yes, my lord.
They'll have a say in, they may say this 1/7 I am not acceptable, that 1/7 I am acceptable. ಇಸ್ನಾರು ಇರ್ಬೋದು. ನೀವು ಯಾಕೆ ನೋಟಿಸ್ ಕೊಡದೆ ಇದು ಮಾಡಕ್ ಹೋಗ್ತಾ ಇದೀರಾ?
ಅದೇ due to the oversight, my lord, the process fee is not paid.
ಆದ್ಮೇಲೆ ಇದು ಯಾಕೆ ಬೈ ಫುಲ್ ಸೈಟ್ ಯಾಕೆ ಅಪ್ಲಿಕೇಶನ್? We'll have to set it aside now.
Yes.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that without issuance of notice to respond number 6A to 6H, in FDP number 1 of 2013, a commissioner has been appointed to effect partition as per the modified decree passed in RSA number 100408 of 2018. The submission of learned counsel for the petitioner is that without notice being issued to respond number 6A to 6H, no partition by meets and bounds can be made. Though the objection has been raised by respond number 4 in the FDP proceedings, the said objections were required to be considered by a trial court inasmuch as a commissioner was being appointed to demarcate the property and allotment of the property by partitioning by meets and bounds, which could not have been effected without respond number 6A to H being on record and being present when the commissioner were to measure the property. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued, the impugned order dated 20/12/24, passed by the principal civil judge and JMFC Court Raibag in IR number 11 in FDP number 1 of 23 at Annexure H is set aside. ನೀವು ಬರೀ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಹಾಕಿದ್ದೀರಾ ಕೇವಿಟ್ಟು?
Yes, my lord. He is the.
What about others?
Others is the
Yes,
dependents, my lord.
Others, my lord, they are the formal parties, my lord. I am the contesting, my lord, in this case, my lord. I am the contesting, that is the respond number one, my lord. That is the plaintiff, my lord.
Memo for dispensation.
They make a-
Memo filed by the petitioner for dispensation of notice to respond number 22.
24.
24 is accepted. Notice to respond number 2 to 24 is dispensed with unhealth. First is set aside. The FDP court would have to proceed with the matter after issuance of notice on respond number 6A to 6H and they coming on record.
Yes.
15, KL Patil.
Give it respond.
Suit for injunction.
Ready? Yes.
I filed a suit for injunction in which my temporary injunction application had been allowed. In the MA that has been set aside,
Yes.
the facts prior to filing of this suit are, my lords. In 1994, an agreement of sale was executed in my favor, delivering the possession to me. I filed a suit for specific performance in 2019. Thereafter, my lords, in the year 2023, there was an interference by the defendants of my enjoyment of the suit property. Therefore, a fresh suit seeking injunction, seeking restrainment from this.
File a specific performance suit was pending.
It is pending. Now, MA court has set aside the order of temporary injunction on the sole ground that suit for specific performance is pending and he could have sought it there. But liberty reserved anta madilla ashte.
I number 39192 is already rejected in original suit 107 of 19, my lord. My lord, the second suit is barred under section 10 of CPC.
You can't file it.
Sorry, my lords.
How can you file a second suit?
Subsequent suit has been filed.
Adral reject agide anta.
That time I was not aware because this entire order sheet I have produced it there.
Petitioner is before this court seeking for the following relief. The petitioner
Filed.
had initially filed a suit
Suit file mirror.
in OS number 107 of 2019 seeking for specific performance of an agreement of sale under which the petitioner claimed that vacant possession of suit property had been handed over to the petitioner. Subsequently, the petitioner filed a suit in OS number 120 of 2023 alleging that the defendants were interfering with the possession of the plaintiff, and as such, OS 120 of 23 was filed for injunction restraining the defendant's vendors from interfering with the possession of the plaintiff. Initially, the trial court had granted an order of injunction which came to be vacated on a first appeal being filed in MA number 9 of 2023. It is challenging the same, the petitioner is before this court. The submission of learned counsel for the petitioner is that irrespective of the suit for specific performance having been filed, a suit for injunction is maintainable since the interference was made in the year 2023, a fresh suit was filed. Alternatively, he submits that the first appellate court having dismissed the application under 39 Rule 1 and 2, the first appellate court ought to have reserved liberty to the petitioner to move a similar application in the pending suit for specific performance in OS number 107 of 2019. Learned counsel for respondent 1 and 2 would submit that in the suit in OS number 107 of 2019, an application had been filed and order 39 Rule 1 and 2, seeking for injunction restraining the defendant then from interfering with the possession of the plaintiffs, which having been rejected.
It is not rejected because if your lordship.
Is what his submission is.
Illa, from that order sheet I have produced.
The subsequent suit could not have been filed.
Will not lie one is taken.
In reply, the counsel for the petitioner submits that no such application had been filed for injunction, no such rejection of the application for injunction has been made. Another application is pending.
Pending 3/9/2021.
Why do you file another suit?
That is there.
After 4 years.
The only thing is whether it is not to alienate.
It's not been rejected and said application is pending. Heard so and so produce papers. The undisputed facts are that the plaintiff had filed a suit in OS number 107 of 2019 for specific performance when application for injunction had been filed. Subsequently, a suit in OS number 120 of 23 had been filed only for bare injunction. the contention of the counsel for the petitioner being that an application filed for injunction in OS number 107 is of 2019 is still pending.
Yes.
Where the contention of the counsel for respondent is that the said application has been rejected.
Taken along with main suit.
Are yet to be taken along with main
Direct,
suit?
the said application is required to be taken up along with the merits of the matter. Looked at from any angle, a suit for specific performance in OS number 107 of 2019 having been filed and an application for injunction having been filed therein, the plaintiff could not have filed a separate suit in OS number 120 of 2023 seeking only for injunction. As such, the First Appellate Court in MA number 09 of 2023 has rightly rejected the application for injunction. If at all the petitioner were to seek for any injunction, it was for the petitioner to have moved the court seized of OS number 107 of 2019 for consideration of the application for injunction, which the court could decide to take up or not depending on the facts of the matter. The order passed by the First Appellate Court, being proper and correct, does not require any interference, reserving liberty to the petitioner to move the court seized of OS number 107 of 2019 in terms of the above observation. Petition stands dismissed.
16 HM Dharwad.
I am appearing for petitioner, my lordship. Kindly I will tomorrow, my lordship. Counsel is out of station.
He list on 24th.
Only on the basis of an interim order passed before the deputy commissioner they in the meanwhile I'll accept notice on that.
And AGA accepts notice for
1 to 4.
1 to 4 ಅಷ್ಟೇನಾ?
ಹೌದು. Private ಇದಾರೆ but private may not be necessary.
Notice to respond number 5 to
39.
39 is deferred for now.
Please.
17 Sudhadi.
Please, my lord. Petitioner, my lords. The petitioner has a license in Form CL2. After securing a suitable premises, he applied for shifting to the same to a new premises in November 2024. Thereafter, in order to make it objectionable, the road was cut in front of one hospital. Otherwise, it would not have been within the restriction under Rule 5 of the rule. Annexure F is the road cut position photograph. That has been questioned in the earlier petition number 107699 of 2024. My lords are pleased to direct notice and even the show cause notice has been issued to the chief engineer through the chief secretary. During the pendency of the same, the inspector of excise under annexure H page 27, who is not the competent authority, my lord, passes an order stating that the distance between the proposed premises is 71 meters and the hospital. Even then it is permissible because it is within the limits of the city municipal council. For city municipal council limit, there is a relaxation to be granted by the excise commissioner. Instead of sending the proposal to the excise commissioner, the inspector of excise, who is nobody to take a decision, without jurisdiction passes an order that is questioned.
Which is the provision? Which is the provision?
Rule 5 of the Karnataka Excise Licenses General Condition Rule. Rule 15, which restricts the premises within
which rules?
Rule 5 of the General Condition Rule. Licenses General Condition Rule, my lords.
General condition of licenses.
Yes, my lord. It specifically says, my lords may kindly see the restriction. No license, my lord got it. Then proviso number 4. After explanation, proviso.
Yes.
Provided that the Deputy Commissioner of Excise may, with the prior approval of the Excise Commissioner, and for the reasons to be recorded in writing, permit the location of any shop within a distance of 100 meters, but not less than 50 meters from the institution, hospital, office or locality space within the city municipal council or corporation limits. This is within the limits of Gangavati City Municipal Council. Instead of doing that, and when the show cause notice is in order to all the respondents in the earlier writ petition, the inspector of excise, who has no authority whatsoever, passes this order.
So 50 meters ಒಳಗೆ ಇಲ್ಲ. Now you are
50 meters
71
is
meters.
ಜಾಸ್ತಿ ಇದೆ, 75 meters ಇದೆ. From one gate, it is 175 meters. From another, this road cut portion, 71 meters. Now the divider is cut, which is pending in the earlier writ petition. Highway, my lord, highway is cut to benefit another licensee, contrary to my interest. And the hospital is also is not owned by a doctor. And they have no objection. 71 meters.
Have you got this? The proviso is not for them to do, it's for you to get it. Provided the Deputy Commissioner of Excise may, with the prior approval of the Excise Commissioner, for reasons to be recorded, permit the location. So this permission you have to obtain, Allah, Mr. Bhatt.
Yes. No. He has to forward. With the Deputy Commissioner has to forward for prior sanction of the Commission. That is the procedure always.
Have you sought for it?
That's what my application is given.
Where is
my
your
application is given for shifting. Page, my lords, my application. Yes.
Lord, first request is at page 20, application is at page 24.
Yes, page 20. Deputy
20 is the request.
Yes. ಆದಷ್ಟು ಬೇಗನೆ ಸ್ಥಳಾಂತರ ಮಾಡಿ ಕೊಡಬೇಕೆಂದು. The ಸ್ಥಳಾಂತರ, if it is found to be within 100 meters.
Where have you sought for exemption of that 100 meters?
They are not, normally, my lord, they are sending the proposal to the, in all cases, I can submit, my lord, in all cases, they send the proposal. The Deputy Commissioner.
They send the proposal and they'll send the proposal in, to set it up in Dharwad. We'll go and do it in Dharwad.
No, Commissioner, Excise Commissioner.
Unless you seek for an exemption, why should they consider it?
No, it is because as on the date when I applied, it was beyond distance. Thereafter, the road divider was cut by using the political influence.
You should go forward and say that you exercise this power, get Excise Commissioner's prior approval, and then give it to me in 71 meters. You're not gone.
No, it is that situation, my lord, was not available for me because when I applied, this road divider was not there.
After that, have you done it, Mr. Bhatt?
Yes.
After that, have you done it?
That is pending in the earlier writ petition, my lord.
Then they are right in the show cause notice. The reply to the show cause notice.
My lord, kindly, it's not the show cause notice, it's an order of the inspector.
But even better.
It's an order, inspector who is no authority. The order has to be made by the Deputy Commissioner on any subject. He is a delegated authority of the Deputy Commissioner of the district.
He is not an authority to sanction, but he is an authority to cancel. You have no permission.
I have not shifted. I have in the original place. Now my application to shift is pending. That has been rejected by the inspector instead of the Deputy Commissioner of Excise.
But in the current location, you are within 71 meters from the hospital.
Yes, that cannot be. Now today's purpose will be the other writ petition is pending. It comes item number 80, 90 like that.
Let that other petition will take it up when it is, but you don't have a permission for this, so you close it.
No, I have not opened, madam. I have not opened. I am in the old place. Rightly, I am there in the old place. I want to come to a new place, which is not considered, which is rejected. I have not moved to the new place. ಎಂಬ ಮನವಿಯನ್ನು ವಿಲೆಗೊಳಿಸಲಾಗಿದೆ.
ಹೌದು.
My application is rejected. That has to be considered.
For all the respondents.
Notice may be ordered, my lord, and it will be tagged on with the other petition.
We are taking the notice and dismissing your petition.
My lord, may I submit, my lord? May I?
Seeking for the following leaves. Yes.
May I try to proceed, my lord? May I?
You are not sought for anything, Mr. Bhatt. The officers are not going to be doing favors to you.
May I submit in all cases? In all cases, the law is not.
No, everything is wrong.
That they are sending Deputy Commissioner of Excise. He seized of the matter. He should have done it. My lord, who is the inspector, my lord?
They are not asking why are you sending.
Who is the inspector, my lord? The Deputy Commissioner of Excise should have examined the proposal. When my lords are seized of the matter, my lord, that now that petition will become, my lord, rendered futile, my lord.
You have
Show
not
cause
made any
notice.
application, Mr. Bhatt. How many times do we have to tell you?
Please, my lord.
I don't think we need to tell you 5 times.
No, my lord, I am only, my lord.
If you have not made an application, why should they consider?
Jurisdiction, my lord, I have question.
Speaking for the following leaves. The contention of Sri S.N. Bhatt, learned counsel for the petitioner is that the communication dated 24/1/2025 could not have been issued by the 4th respondent inspector of excise, Gangavati Range, Koppal district. In the event of the said excise inspector having come to a conclusion that the location to which the petitioner proposed to shift his excise license shop under CL2 was within 100 meters, then the said inspector ought to have referred the matter to the Deputy Commissioner of Excise, who, after obtaining prior approval of the Excise Commissioner to be recorded in writing, could permit the location of any shop within a distance of 100 meters, but not less than 50 meters from the institutions like the hospital, office, or locality specified in Sub-Rule 1 of Rule 5 of the Karnataka Excise General Condition of License (Close Rules 1967). His submission is that instead of doing so, the request of the petitioner has been rejected, which could not have been done. Having gone through the application submitted by the petitioner and the documents produced along with the writ petition, it is clearly seen that the petitioner only sought for shifting of his licensed premises under CL2 to the location specified in the said application. The petitioner did not seek for any exemption as regards the distance from a hospital which is situated nearby. It is not in dispute that the hospital is situated at 71 meters distance from the proposed location. The petitioner not having made any request or application to the Deputy Commissioner of Excise or the Commissioner of Excise for grant of exemption or reduction of the for grant of exemption by permitting the petitioner to shift to a location less than 100 meters, and the considered opinion that there was no requirement for the Inspector of Excise to forward the same to the Deputy Commissioner or the Excise Commissioner as contended by Sri Bhatt. They do not find any infirmity in this said order. The petition not making out any ground stands dismissed.
May I? This may not affect the earlier writ petition, my lord.
That we will consider it.
And that may be ordered to
You-
be.
You should make applications.
Item number 19 ಬರ್ತಾ ಇದೆ, ಹಂಗಾಗಿ I could not persuade my lord.
We'll take it up when it comes.
Please.
Yes, Mr. Mardi.
Is a writ of mandamus, my lord. To initiate the
Acquisition
excess land, my lord. As per his lands are coming under the restricted area, my lord. Within the middle of the railway track, 30 meter of the either both the sides, my lord. It is a totally restricted area by the railway department. And my land is coming under that restricted area. They have to initiate that acquisition proceedings, those land also, because these are the commercial land, my lord. These are the commercial Indian lands.
And AG accepts notice for respond number
1, 4 and 5.
1, 4 and 5.
1, 2.
Sri MB Kanvi accepts notice for respond number 2 and 3. Counsel for the petitioner to serve 2 sets of the petition along with annex on the said counsel. Relist on 24th.
19. Vinay Kaushulgi.
Lord, for 2 also I accept. 2, 1, 2.
2 also.
Yes.
Spot number 1, 2, 4, 5. Only number 3 is.
2 MB Kanvi 3.
Please.
Yes, Mr. Kaushulgi.
Please, my lord. Order of the Deputy Commissioner and Appellate Tribunal is under challenge. The Deputy Commissioner rejects my 7A application on the ground that I had filed the application with after the prescribed limit at paragraph number 23, my lords, 4th paragraph. Karnataka Bhu Kandaya ಭೂ ಸುಧಾರಣೆ ತಿದ್ದುಪಡಿ ಕಾಯ್ದೆ 1996 ದಿನಾಂಕ 15/2/90 ಜಾರಿಯಲ್ಲಿ ಬಂದಿದ್ದು, ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ ದಿನಾಂಕ 2/11/98 ಜಾರಿಯಲ್ಲಿ ಇದು ಬಂದಿದೆ. ನಿಯಮ 226C ಮೇರೆಗೆ ನಿಯಮಗಳು ಜಾರಿ ಬಂದು 3 ತಿಂಗಳ ಒಳಗಾಗಿ ಅರ್ಜಿಯನ್ನು ಮಾಡಬೇಕಿದ್ದು, ಅಂದರೆ ದಿನಾಂಕ 1/2/1919 ಒಳಗಾಗಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಬೇಕಾಗಿರುತ್ತದೆ.
Where is the RTC?
But application is produced, my lords.
RTC ಎಲ್ಲಿದೆ?
Pardon, lords?
RTC.
RTC annexure A, my lords.
ಭೀಮಪ್ಪ, ದೊಡ್ಡ ಸತ್ತಪ್ಪ, ಭೀಮಪ್ಪ.
And annexure B is the application. Annexure B is the application. I filed it on 4th December 1998. ಅವ್ರು ಹೇಳೋದು 1/2/1919 ಒಳಗಾಗಿನ ನಾವು ಹಾಕ್ಬೇಕಾಗಿತ್ತಂತ. I had filed, but the wrong date has been mentioned and my application has been
So you filed it on 4/2/98.
4 December 4/12/1998.
4/12.
I would have filed it before 1/2/1999 ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಅಲ್ಲಿ 30th 4/1999 ವಿಳಂಬವಾಗಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ.
ಸೀಲ್ ಇದೆಯಲ್ಲಪ್ಪ.
4th December 1998. Annexure B. Order submission.
DG access notice for respond number 1, issue notice to respond number 2 to 4, returnable by 21st March.
I sought for interim order, my lords, because I am in possession of the property.
The operation of the order date 7/9/2016 at annexure C and 7/2/2020 at annexure D as stated till the next date of hearing. Respondents are also restrained from in any manner interfering with the possession of the petitioner till the next date of hearing.
Please.
Process fee and copies to be furnished by end of day 19th, failing which the interim order will stand automatically vacated.
29 Kumar.
Yes.
Lord, my application, I number 23 has been rejected by the trial court. We had sought for a direction for production of documents from the office of the Assistant Commissioner.
Suit for?
Suit for partition, madam. The the respondents had executed a Kabuli Patra in favor of the petitioner's husband, who is now deceased, in the year 2010.
RTS appeal file, you can always apply and a certified copy and furnish it.
Yes, my lord, but in this matter.
The public document.
Yes. But the original Kabuli Patra is produced in the RTS appeal by the original Kabuli Patra executed by the respondents is produced in the RTS appeal.
ನೀವು ಅದೇ ಹೇಳಿಲ್ಲ RTS file ಅಂತ ಕೇಳ್ತೀರಾ.
Yes, my lord.
You are only asking for RTS appeal file.
Along with the documents. Along with the documents. In page number 46, my lord, the PW1 has, in cross-examinations, he has stated that she would identify her signatures on the appeal memo, documents produced in the RTS appeal.
ಎರಡು ಸತಿ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Yes, my lord.
ಮತ್ತೆ ಸೇಮ್
The
ಅಪ್ಲಿಕೇಶನ್.
second application has been filed to, we are in need of that original Kabuli Patra, my lord.
Yes, but your earlier application which you filed,
Yes,
to summon Tahsildar was rejected.
Yes. Yes, my lord.
And ಮತ್ತೆ you filed an application to summon the Assistant Commissioner, that was rejected. Now again you filed an application to summon the Assistant Commissioner to produce the same document.
Yes, my lord. I mean, my lord, the trial court has framed an issue. Issue number 1.
Yes, but once an application has been filed and it's been rejected, can you file another application? ಒಂದ್ಸತಿ ಫೈಲ್ ಮಾಡಿದ್ರ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು,
Yes, my lord.
ಮತ್ತೆ ಅದೇ ಅಪ್ಲಿಕೇಶನ್ ಇನ್ನೊಂದ್ಸತಿ ಹಾಕಕ್ಕಾಗತ್ತಾ?
But that second application was filed on the admission given by the respondents in the cross-examination.
Same application, Mr. Counsel.
Yes, my lord. My lord, if that Kabuli Patra is produced and confronted, then their case would not survive.
ಚಾಲೆಂಜ್ ಮಾಡಬೇಕಾಗಿತ್ತು ನೀವು. ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ರೆಸ್ ಜುಡಿಕೇಟ್ ಅಲ್ಲಿ ಬಾರ್ಡ್ ಅಂತಾರೆ.
Yes, my lord.
That is what the court has held.
Yes, ma'am. And moreover, my lord, the respondents have suffered an order before both the Tahsildar and the Assistant Commissioner. Their appeal has been dismissed. The whole
You
case is
produce the
resting.
certified copies now first.
But kindly see page number 46, my lord. 46. Wherein the PW1 has given an admission. ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳನ್ನು ತಂದು ಹಾಜರುಪಡಿಸಿದರೆ ನಿನ್ನ ಹಾಗೂ 1ರಿಂದ 3ನೇ ವಾದಿಯರ ಸಹಿಯನ್ನು ಇರುವ ದಾಖಲೆಗಳನ್ನು ತೋರಿಸಿದರೆ ಗುರುತಿಸುತ್ತೀಯಾ ಎಂದರೆ
ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಪ್ಪ ಮುಂಚೆನೆ.
ಎಸ್ ಮೇಡಮ್.
ಮತ್ತೆ ಅದೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ ಬರಲ್ಲ.
The earlier application is A number 14.
We can only reserve liberty to apply for certified copies and produce it.
We have produced it, my lord. We have produced it.
ಎಲ್ಲಿ
We have produced it before the trial. We have applied for the certified copies and we have produced it. But due to that specific contention, I mean admission given by the respondent, we are in need of the original Kabuli Patra. If that original
certified copy of that document is there.
No, that was not given to us. If that was only the RTS appeal memo was available to us.
It was earlier application was dismissed on the ground that the Tahsildar officer said that the document is not available.
Not available.
If it is not available, how can it be produced?
Not in Tahsildar office. The matter is now disposed in the Assistant Commission. The file is available in at the Assistant Commissioner's office, my lord.
The application filed to someone, the Assistant Commissioner was also rejected on 11/3/22.
Yes. That was matter was disposed on 11/3/22, my lord.
You cannot file the same application once again.
No, the original, all the, once the appeal was disposed in the Assistant Commissioner office, the files are in the Assistant Commissioner's office.
Certified copy apply madi.
We had applied, we have produced it before the trial court. But they are, I mean, the respondent saying that they will only identify the signatures on the original document.
Where have they said that?
Here, my lord. Page number 46.
46.
Page number 46.
Hmm.
In the
Confront
cross
madid-
exam, yes.
Confront madidra.
Using the certified copy, we have confronted them, but they have categorically given admission here that in page number 46, my lord.
46.
46.
Hmm.
ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳನ್ನು ತಂದು ಹಾಜರುಪಡಿಸಿದರೆ ನನ್ನ ಹಾಗೂ 1ರಿಂದ 3ನೇ ವಾದಿಯರ ಸಹಿಯನ್ನು ಇರುವ ದಾಖಲೆಗಳನ್ನು ತೋರಿಸಿದರೆ ಗುರುತಿಸುತ್ತೀಯಾ ಎಂದರೆ ಸಾಕ್ಷಿಯು ನಾನು ಸಹಿ ಮಾಡಿರುವುದಿಲ್ಲ. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ನನ್ನ ಸಹಿ ನಾನು ಗುರುತಿಸುತ್ತೇನೆ, ಅವರ ಸಹಿ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. The whole case rests on the Kabuli Patra, Mama. They have relinquished their right in the property. Simultaneously,
He's only said that he can
identify the
his
signature.
own signature.
His own
Not
signature.
other persons.
Yeah,
The original produce madidanu eno.
But we'll confront the same with the others also.
You confront it.
How about the original document is required? my lord.
Nobody has said original is not produced.
But that is the issue. Now,
He has identified his signature.
no, she would identify if the original documents are produced here. What that's saying.
ಮೇಲ್ಗಂಡು ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳನ್ನು ತಂದು ಹಾಜರುಪಡಿಸಿದ ಒರಿಜಿನಲ್ ಅಲ್ಲ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬಹುದು.
Certificate. The original, we only need that Kabuli Patra, my lord, not the appeal memo and Wakalat which they have filed. The original Kabuli Patra is in that file, RTS appeal. If that particular document is made available to us, then the plaintiff's case would not survive for consideration. They would not be tenants in common.
The Kabuli Patra has not been acted upon.
It has been acted upon. Now, when we filed an application to mitigate the revenue entries in our name, the respondents filed their objections. And
This won't succeed. If we stay it also, it won't help you. Because your application that you are filing, stay no ಕೇಳಿಲ್ಲ ನೀವು. You'll only
that's
issue
not for
notice.
stay, man.
Issue notice to the respondents returnable by
Also, my lord, the page number 38, my lord. Page number 38, last para. With
We are issuing notice, but it won't help you. Written out by 9th April.
9th.
My lord, with kind permission. The previous matter, the lordship was pleased to grant an interim order. But the findings before the appellate tribunal holds that the petitioners are not in possession and he has failed to substantiate his claims so far as possession is concerned. And is claiming through by way of an adverse. That is the finding given by the tribunal. Lord, may I take it to lordship at page 34, K80 order. Especially at para number 12, page 36. Para 12, my lord.
Password. Take advertising.
21, Sardesh Pandey.
I request on Monday, Lordship.
The request of counsel for respondent released on 24th.
Yes, my lords. I'm for the petitioner, my lords. Last
Interim
time-
order idea?
Last time it was a parted matter.
Yes.
Interim order
That,
earlier granted is.
It was heard for some time in the last occasion.
Regarding acquisition of the,
I require some more time, Lords. There are judgments, my Lords, with regard to my Lord.
You won't have any judgments on this.
My Lords?
You won't get any judgment on this.
That's also.
Fourth, at the request of counsel for respondent, if on that date arguments are not advanced, the matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner.
24th.
For further hearing at 2:30 p.m.
24th. Please, much obliged.
22, Y. Lakshmikant Reddy.
Lords, I am for respond number 1. I filed IA for withdrawal of amount.
ಅವ್ರ ಮುಂದೆನೇ ಹೋಗ್ಬೇಕು. ನಾವು ಮಾಡ್ಬೋದು.
Lords, during the pendency of the petition, my lords, 3 lakh was deposited before this honorable court.
ಮಾಡ್ಬೋದು. Yes.
My lords, during the pendency, 3 lakh rupees were deposited before this honorable court by the petitioner. And due to oversight, my lord, at the time of dismissal of the said petition, there was no order passed for withdrawal, for the release of the said amount.
By virtue of which order was the deposit made?
My lords, it was deposited on 22/11/2022 and 9/12/2022.
Disposal ಏನಾಯ್ತು?
3/11/2022, my lords. On 3/11/2022, it was directed by this honorable court.
So petitioner had deposited.
Petitioner has
You
deposited.
are?
I'm respond number 1, my lords. I'm the decree holder. Is the JDR number 1 who had filed the petition.
Lad, counsel for respond number
Respond number 1.
1. Submit that the respond number 1 is decree holder and the deposit made in persons ordered dated 22/11/2022 inheres to the benefit of respond number 1 decree holder. And it's in that background that IA 1 of 25 has been filed seeking permission to withdraw the said amount. None has appeared for the petitioner nor is any objection filed to said application. Take into consideration the order dated 22/11/22, the amount in deposit being made to secure the decree holder. The amount in deposit is permitted to be withdrawn by the decree holder, by decree holder respond number 1 by complying with the due formalities. IA 1 of 25 is allowed.
23, Srinand Pachapure.
Milords, in this matter, pleadings are all complete, Milords. It was understood to be heard. I am ready, Milords.
Seek for accommodation, my lord, because we had
As
engaged
state,
senior
my lords,
counsel
at
in the
their
matter.
instance, it has been
and,
listed.
today
Senior
is
counsel mentioned.
Principal bench, my lord. But engaged a senior counsel in the matter. Yes,
He is
Principal bench.
representing the High Court of Dharwad there. Alva. Yavaga.
Next week, my lord.
Tomorrow or day after, Milords. GMCPC matter, Milords.
24th.
Please.
The request to counsel for respondent number 1, we list on 24th.
Please, my lord.
24, Sunita P. Kalsur.
Appeared for the petitioner's counsel, Milord.
Legible copies of B, D and D1.
I have produced the legible copies today along with the memo, your lordships.
Municipal Council
Yeah,
respondent number
one
4
moment. Just one moment, Mr. Patil.
is constructing
Just
a,
one moment, please. B and D produce my D1.
D1 is same, your lordships, the same tax paid receipt I have produced, your lordships. Fresh receipt I have produced. Other 22, 23, 23, 24, other than 24, 25 fresh receipt I have produced now.
You have to produce what you have produced earlier, not a new one.
That's the reason I have submitted in the memo, your lordships. I will kindly be permitted to produce a fresh tax paid receipts.
Now, what you just mentioned was you have produced it
Yes.
along with a memo. Now you have replaced it with another document. Can't accept these kind of submissions, madam.
Last occasion, because we are not able to get the better copies of those, your lordships.
Yes, so we'll reject your memo and direct you to comply with it. And Mr. Patil will go back without arguing this matter. We don't entertain these kind of submissions.
Your lordships, the only receipt,
That you should have come clear beginning,
your lordships.
not by saying that you have produced.
I apologize, your
A
lordships.
memo has been filed. You can apologize to Mr. Patil now. A memo has been filed enclosing, said to be enclosing legible copies of Annexure D and B and D. A perusal of the same, though indicates the legible copy of Annexure B having produced, the document stated to be Annexure D is a different one than that produced along with the petition, not the same one. The legible copy of Annexure D1 has also not been produced. Hence, the memo insofar as Annexure D is concerned is rejected. Counsel for the petitioner is granted 10 days time to produce legible copies of Annexure D and D1. We list on 4th March.
25, Suraj Paloli.
Yes.
I had filed the
May I
IA
seek
for
the extension of interim order is existing.
Interim order is not extended. We don't like this wrong submissions being
Your
made.
lordships,
You made a wrong submission.
I apologize, your lordships, only the interim, because.
Sorry. Yes.
I have filed the
I
IA
seek
for
the permission
correction.
of the court, your lordships.
No,
I
madam.
produce the typed copy within 1 hour, your lordships.
You produce it, but you made a false submission. That we don't like.
Your lordships,
And that we will not encourage.
I'm not, I apologize for that.
Your apology is accepted, but interim order not extended. Clearly.
Kindly, your lordships, because the construction
Sorry,
is.
if you make a false submission, we will come down heavily on it.
Your lordships, I apologize for that. That was not my false submission, your lordships. Kindly, I seek the.
Madam, you rejected it thrice.
Subject to producing, your lordships.
Counsel for the petitioner seeks for extension of the interim order. The submission being made earlier being false, the request for extension is rejected. Yes.
My lord, in the judgment para, my lord, in the third para, may I read, my lord?
Yes.
Learned counsel for respondent back would submit that the petitioner was permitted to remove the machinery. My lord, it is uncharged machinery should have been added, my lord. It has been uncharged is left out with the. There are certain assets which are charged, my lord.
That cannot be removed.
That uncharged machinery.
ಎಲ್ಲಿದೆ ಅದು?
Para 3, third line, my lord.
ಅಲ್ಲ ಇದರಲ್ಲಿ petition ಅಲ್ಲಿ.
Petition, my lord, their prayer, my lord. Prayer number 2, my lord.
Uncharged assets.
Uncharged, sir.
Matter has been moved for being spoken to.
Correction of.
For correction of the judgment by filing IA 1 of 24. That counsel for respond number 1 to 3 bank submits that the word uncharged has been inadvertently omitted in line 3 of para 3 before the word machinery. A perusal of the prayers sought for by the petitioner.
And also on line 4, para number 4, wherever the machinery is there, my lord. Para number 4, line 2.
Well summed. The submission of learned counsel for respond number 1 to 3 is that the removal of machinery which has been permitted is only as regards uncharged machinery.
Please.
By inadvertence, the said word uncharged is not found mentioned in the order sheet when the word machinery has been used. In that view of the matter, the registry is directed to correct line 3 of para 3 by adding the word uncharged before the word machinery.
And line 2.
Line 2
Para
of
number.
para 4 by adding the word uncharged before the word machinery.
And also in line 5 of the same.
Line 5 of para 4. Astella.
Aster.
Please.
The issue of fresh certified copy, IA 1 of 24 is allowed.
Please.
26, Mrityunjay Tata Bank.
Yes.
Impugned order is of the land tribunal. Dated 27/8/1997. My lord, the subject matter of the present, my lord, two lands are survey number 40 and 45. My lord, measuring 23 acres 15 guntas and my lord 30 acres 19 guntas. These two properties along with other two properties bearing survey number 30 and 38 were leased to the fifth respondent company by way of registered lease deed in the year 1921.
1931.
1921. 21. With an object that the entire land would be used for the manufacture of the bricks. Lease expired in the year 1961.
Was for a 30-year period, lease.
40 years period.
21, 40 years.
40 years period. They did not hand over possession of this lease premises. Hence, my lord, the suit was filed in the year 1970.
After 9 years.
Yes, my lord. Suit was compromised and my lord, lease was extended till 2017.
When was the compromise?
Pardon?
Compromise was?
78, my lord. 6/3/1978. My lord, may I request, my lord,
extended till December 2017.
31st December 2017.
Another 40 years.
Another 40 years. My lord, when this compromise was being executed, my lord, the fifth respondent company, which is specifically, my lord, which has taken this premises for the construction of the bricks, makes an application in form number 1 under the provisions of certain Enhanced Abolition Act.
Form number 1?
Yes.
Enhanced Abolition.
Then, my lord, form number 7 is filed. My lord,
by a company. By a company.
By a company.
Yes.
My lord, may I request, my lord, the clauses in the compromise deed itself. My lord, page 31.
Form number 1 was filed on
29/6/1981.
29/6/1981.
81.
And 7A na?
Illas. Form 1 as well as Form 7.
Now, certain.
Both are filed.
7 was filed in 74
Uh,
or 7A because 81
no,
under mostly
26/12/1973.
26/12/1973 Form 7.
Form 7.
Yes.
Then Form 1 is filed on
29/6/81.
29/6/1981.
Yes.
My lord, for a minute, my lords may kindly take the recitals in the compromise, the terms. My lord, page 31. 31, my lord.
This
There are two
compromise
suits which are filed.
was in 78 after the filing of Form 7.
Form 7. The plaintiff, my lord, clause 1. The plaintiff is a lessor and defendant is the lessee of the properties bearing number so and so, so and so. The period of the lease of the suit is extended up to 31st December 2017. The rent for the first term, first 10 years is so and so, so and so. Then, my lord, clause 4. Lessee has an option to extend the lease period for a further period of from after 31st December 2017. Then, my lord, I will not read the other clauses. My lord, clause 16. 16, page 33. The lands are already put to non-agricultural use by the lessee since 1921. Even then, if a formal permission is necessary, lease may apply for the same and lessor will give his help and consent for the same. This was executed on 6th March 1978. Then, my lord, kindly take, my lord, the Form of 7 that was filed. My lord, pursuant to this, my lord, possession is handed over, my lord, on 6/2021.
Pursuant to this?
My lord, the lease was extended till 2017. Then, my lord, possession is handed over to the petitioner.
After 17.
Yes. Now, my lord, may I request, my lord, the Form 7 that was filed. Form, my lord, this is page 57. This is annexure to Form 7 that was filed. Note, the so-and-so industrial Khanapur has been established in the year 1921 and the company is manufacturing tiles and clay articles. The company took the lease of 40 years, the survey number so-and-so, so-and-so, my lord, after which are, my lord, 2 or before, my lords. In survey number 30 and 40, there are factory buildings and 38 and 45 are used for excavating clay. At no time, the lands are used for agricultural purpose and no crops are raised. But though the mistake, the record of right, the lands are shown as crops are grown in some parts and the name of some persons are shown in as tenants. But there are no tenants as all the lands are actual possession of the company. As regards so-and-so, survey number so-and-so, the company took survey number on lease for so-and-so period. Then, my lord, the owner Sri so-and-so Swami of so-and-so Mutt filed OS 128 of 1970 and 129 of 1970 in the Civil Code Belgaum against the company and persons whose names appears in the record of right through mistake. The said person, though served with the notice, did not appear in the suit and contested they remained absent. It is not necessary to file Form number 7 by the company, but to be on the safer side without prejudice to the rights of the company, which have safer side, be on the safer side without prejudice to the rights of the company, which have acquired to it for using the lands for non-agricultural purpose. Form is filed. The tribunal may give such reliefs as is available to the applicant company as per the law. If the tribunal comes to the conclusion that lands are agricultural lands, then the occupancy rights to the applicant company. My lord, this is Form number 7. Then, my lord, kindly turn to Form number 1 that is filed over the page 59. My lord, the applicant.
We'll come back. The owner is
Mutt.
Mutt.
Yes.
And who is this Gavada Krishna Vittal?
Rival claimants. My lord, rival tenant. There are 2 rival claimants. My lord, in respect of the small portion, 4 to 5 acres. All the applications were clubbed together. My lord, application 1 filed, application 7, 1. Then, my lord, rival claimants, Form number 7 were clubbed. order was passed rejecting their claim, accepting, my lord, the claim of the company.
Now both of you are together.
No.
You're fighting.
Yes.
No, it went up to Supreme Court. And Supreme Court
I'll come to that.
affirmed the order passed in my favor.
I'll come to that.
They were party to that and they did not challenge or they did not refer anything.
One request, one admission matter is I'll finish up and come.
We'll finish the Bangalore list and come back.
Great, great.
ಸರ್ ನಮ್ 19 ಪಾಸ್ ಓವರ್ ಮಾಡ್ಯಾರ ಮತ್ತೆ
ಪಾಸ್ ಮಾಡ್ಯಾರ ಪೊಸಿಷನ್ ಇಲ್ಲ ಅಂತ
ಆಫೀಸಿನ ಕೆಲಸ ಹಾಳಾಗಬಾರ್ದು. ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ರಿಪೇರ್ ಆಗಲ್ಲ.
ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಆಮೇಲೆ ಬಂದು ಗೊತ್ತಾಗಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. ನೀವು ಸ್ವಲ್ಪ ನೋಡಿ ಅದು. ಹಾ ಲಿಸ್ಟ್ ಬಿಡ್ತಾರಲ್ಲ ಅದನ್ನ ಸ್ವಲ್ಪ ನೋಡಿ.
ಸರಿ ಸರ್ ಆಯ್ತು.